Any mention?
Yes. What's it for today?
Well, it was supposed to hear it today.
Is that correct?
Yes, because on the last occasion, my lord, there was this, we had filed an additional document, and your lordship says that this is not something that we'll take it up right now. We will first go on to the writ petition. That additional document, my lord, there was an objection raised by the state by saying that you have enhanced the scope of the writ petition by bringing in the reason how the implementation of the scheme has happened. So we said, fine, in that case, my lord, we'll keep that separate and we'll only hear the writ petition, where our primary concern is about the taking away our profit of 20% to 15%. So we'll stick to the writ petition.
Primary concern is 20%.
20%, which has been reduced to 15%. Yes, my lord, now. In terms of the new notification.
What about the linkage between the implementation of that new device?
Yes, my instructions are, my lord, that it's still not been notified and it's not gone live. But we're still continuing the sales as it is.
No.
Without being,
I mean, there's no link between the profit and that.
Yes, that is.
The manufacturers are bearing the cost.
Absolutely no link.
So that is what I have to, in fact, show your lordships that how I have come before your lordships in regards to the linking of the scheme as well as the introduction of this notification, my lord.
But so prayer is not that, my lord. Prayer is not that. Yes. What my friend is arguing is something outside the writ petition. Completely outside the writ petition.
Lordship pleases.
Yes.
I'll start from the first annexure, my lord, which is annexure 42 of the writ petition, my lord. So this is how the first time, my lord, the scheme in terms of the maximum profit was introduced for the first time in 2017 by amendment of a 372. That is annexure 42, my lord. This is 8th of May 2017. If your lordships permit me, in exercise of the powers conferred under 36 of the Meghalaya Excise Act as adopted by the Meghalaya, the Governor of Meghalaya is pleased to make the following amendments to the Meghalaya Excise Act and rules of 1910 and Assam Excise 1945. These rules are called the Meghalaya Excise Amendment Rules, and they shall come into force with immediate effect. The amendment is amendment to 372, my lord. This is important. The fixation of maximum retail price. The maximum retail price for each kind of liquor, beer, wine is fixed by the Commissioner of Excise every year. The MRP is derived, this is important, my lord. The maximum retail price is derived by adding the ex-bond price, the ad valorem, pass fee, VAT, and the maximum percentage of profit allowed for each brand. So for the first time, my lord, this was introduced in 2017 by fixing the maximum profit. In terms of that, my lord, number 2, MRP shall be printed on the labels and on the body of each of the bottle cans of the company, distillers, brewery, so and so, at their own expenses. Now, in terms of that, my lord, MRP is fixed on the maximum percentage and is approved at a time of registration of labels. If the company wishes to change the MRP, they can do so by registering the label with a new MRP for approval. Now, B, my lord, is important. The kind of liquor and maximum percentage of profit allowed on retail sales is, including 1 to 7, my lord, is fixed on the right as 20%. So this is the amendment for the first time by which the maximum profit was brought as 20% even to retailers.
This was in
2017, my lord. For the first time, 20% was introduced.
So they fixed the 50%,
yes, my lord.
20% margin on all kinds of alcohol.
Yes, which was fixed with the maximum retail price.
Okay.
So after this, my lord, in 2020, 15th of October, there was at page 44, my lord.
What about 43?
My lord, this is all, what happened is from 2017, 2019, 2020, 2021, there were a lot of amendments that happened. The important amendments which I have annexed, my lord, the next amendment is at page 44, my lord. It's at 15th of October 2020. This is the amendment that has happened to the Assam bonded rules, which is the Meghalaya bonded rules, my lord. That amendment happened on 15th of October 2020. And at page 45, in terms of the amendment that happened in 2017, page 45, number 12. the minimum profit was brought into here. The minimum profit margin eligible for bonded warehouse on their sales of retailer IMFL off and on license shall be 8% for IMFL brands only except the bottle in origin. So the 8% was introduced here in terms of the 2017. Subsequently, my lord, when this was brought in, a representation was filed by the petitioners. That is at page 47, my lord. The apprehension started from then.
Now,
This is- Yes, madam.
slow down a bit. The minimum profit margin eligible for bonded warehouse on their sale
Yes.
to retail IMFL. So that means the profit from the manufacturers to the bonded warehouse 8%.
8%.
And then, as per the 2017 amendment, you allow 20% profit.
20%
on
profit.
After lifting it.
Yes.
After lifting it from the bonded
So the
warehouse.
price that will come after the amendment will be the total cost, which will include the 20%. So
factor
the
in that 20%.
20%.
Right.
That is 2017.
Right.
That price has been
Now,
going
now
on.
this is in 2020.
Yes, my lord. There was an amendment brought in.
Warehouses.
Yes.
They fix it 8%.
8%.
How does it affect you?
It doesn't affect. I'm only talking about the manner in which these schemes, these kind of introductions happen in this state.
Okay.
Because this is important because finally, my lord, from 2017 till 2025.
You mean to say before 2020 there was no percentage fix for bonded warehouses?
So this is how it has originated.
Is that correct, Mr. Arvind? Suppose
This is the
before
notification of
2020,
15th of
that
October.
means, they could sell the bonded warehouse could
No, my lord,
to release to the retailers any price they wanted.
No, it's not that, my lord.
Then?
My friend is not correct. Let me explain
So
this.
if you can just explain first, since,
Yes, I scheme,
how,
your lordship.
see, how does it work?
How
fine.
it works?
Suppose you are a manufacturer, you release it to the bonded warehouses.
No, it is not like that, my lord. This process.
They lift the
No,
problem.
let me explain.
They pay
What-
VAT, they pay excise.
No. Process is, my lord, that under the rules, requirement is that manufacturer has to get the brand registered with the
No, yes,
state
that-
government.
that's-
I'm step one, my lord.
Yes, step one.
When the second step is that when they get the brand registered, at that stage the price of price is fixed on the brand, because price of the brand in Meghalaya
So
cannot.
when they register, that brand is fixed by the excise department.
The price is also fixed by the state government, keeping in mind all these percentages or the commissions. The price of the imported liquor in Meghalaya cannot be higher than Assam, because that is the requirement.
Okay,
Comparable.
for that part.
So therefore,
just how the things roll. That's all.
yes. So maximum cap is fixed. Maximum cap is fixed, my lord. Within that, commission of each of these retailer, bonder, and central bonded warehouse is fixed. So therefore, they have no kind of leeway where they can have the price beyond the price fixed by the state government.
Please
That is-
continue. Yes.
So that's when this 20% is included, my lord, in 2017, there is a price which is fixed by the department. So the cost cannot vary. The price along with your maximum profit is also included in that price. So if a price list is sent to me in 2017, my lord, that price list will include everything, because that's the
Mr.
component.
Spoken, that means suppose MRP is fixed at 100 rupees.
Yes.
Are you at liberty to sell it at 80 rupees also?
That would depend on the profit that I have based on that
20%
brand.
profit, okay. On the
I have been given
20%
20%.
Now you say, okay, fine. Like to make my goods more attractive.
Yes. Yes, I can.
You can do it.
I can do it, because if it is 100 rupees, my lord, the 20% which has come to me, which is fixed by 2017.
20 rupees. Huh?
Yeah, 20 rupees. I'm just giving a general idea, my lord. In that 20 rupees, my lord, I have a liberty where there's a situation coming up in any kind of an occasion, I can reduce it by 10 rupees, 20%, 20 rupees or
It's not
something.
mandatory that you
No.
have to take.
The MRP is fixed based on all these components. The components are mentioned here. This is ex-bond price, ad valorem, pass fee, VAT, and maximum profit. So when it comes to me for 100 rupees, my lord, it is coming to me as a complete package to me. Right.
Please proceed.
So in terms of that, my lord, a representation was sent on 23rd of July 2021. That's at page 47. This representation was sent in terms of the amendment that happened on the bonded warehouse, where 8% was included. And the relevant part, my lord, is
How
part.
does it affect you? That's what we wondered.
Yes, I'm just coming to that, my lord. I'm just, because I'll have to link it, my lord, to show that how has it affected me.
Right.
Yes, my lord. Number one, on that representation, my lord, page 47. That, sir, the notification dated 15/10/2020, which is the notification I just now read at page 44, my lord. The state government bonded warehouse amended rules that by the said amendment, state government has inserted a new rule 44 to the principal rules. The rule that under the new 44, the state government has empowered the Commissioner of Excise to issue a license of central bonded warehouse with approval of the government. Number two, in our understanding, the new policy, the taxation structure shall remain at the same of 8% of taxation by the government, and as such it appears that there are no additional benefit to the state government under the new policy. Now it is important, my lord, that the creation of the central bond house, it now appears that in order for them to earn the portion of profit margin, it is apprehended that the portion of margin of the profit of the wine dealers and shop might be handed over to them. So the introduction of 2017 and the subsequent of 2019, by which certain prices were refixed, ad valorums were introduced, this notification, this is the consequences that arose. Subsequently, my lord, after 23rd of July 2021, Lordships will take to the counter affidavit that has been filed by the state government. So subsequently, my lord, from 2021, 2022, 2023, there were a lot of amendments that happened here. Those amendments includes refixation of price, introduction of certain VAT, ad valorem were introduced in certain perspective, and those amendments have been filed accordingly. Now, my lord, in 2025, that is at page 45, my lord, of the affidavit filed by the government.
The first affidavit.
Yes, my lord, the first affidavit filed by the government in terms of the
One
petition.
affidavit.
Yes, only one more.
45, yes.
Page 45. The date is 23rd of January 2025, my lord. So in terms of this, there was an amendment that happened.
Yes.
This amendment were called as the Meghalaya Excise Amendment 2024. By this amendment, my lord, at page 46, a new rule was inserted, 378. So your lordships will remember 2021, my first representation. In this it says that the principal rule after rule 377, the following new rule of 378 to be inserted. The rule is that the integrated excise management system, an online end-to-end integrated excise management system, IEMS, cum track and trace solution shall be set up in the state, which shall include the facility to automation of the excise of functionalities of all liquor bottles with QR code based on hologram, besides other modules for the real-time monitoring. So the scheme, my lord, in terms of my apprehension, was introduced by them by inserting 378. Now the relevant part of this is the number 2 clause in the same page, my lord. All distillers, brewers, bottling plants, central bond house, bonded warehouse, wine shop shall install the requisite track and trace hardware and software as per the specification provided by the excise department. So the entire software will be provided by them, and we will have to install that for us to introduce the system. Number 8, my lord, the implementation of the integrated excise management system cum track and solutions, all type of licenses, my lord, I'm reading number 8 of the same, renewals, brand label registration, renewable issuance of import and transport permit passes, export permit passes, export verification certificate, genuineness of import permits, transit permits, pass, and all other functionalities shall be carried through integrated excise management cum track system from the date of implementation onwards. Compliance of this shall be ensured by the department. Number 9, the cost of implementation as affected from time to time of both the software and hardware shall be borne by the distillers, breweries, bottling plants, companies, and added to their cost separately.
Yes, that mandates that.
Right. So
How
this
do
is
you link it with your 20%?
how do you? Yes,
How do
my
you
lord.
link it?
I'll come to
Yes.
that, my lord. In terms of this, my lord, same affidavit, my lord. Lordships will come to page 61.
Of the same affidavit.
Same affidavit, my lord, page 61. So in terms of the amendment, my lord, the scheme is introduced now. The scheme has to be done in regards to a party who has to implement the IMAS. Page 61 is the
contract
agreement.
agreement.
Yes, the agreement which the government has executed with a private party to implement the scheme.
Okay.
So this is the first agreement that was implemented, my lord. This date of this agreement is 24th of March after the insertion of 378, which I pointed out at 23rd of January. In terms of this, my lord, at page 65 is where they say that means the period in which the project has to go live is at page 65. So the implementation has been predicted as to be when the day it goes live. That's at page 65, point number 1.1.19. Project implementation phase means the period between effective date and go live date.
That's a project implementation. 1.1.1.
1.119. Yes. On the next page, my lord,
Now it says means a period between the effective date and,
And
go live
the
date.
go live date.
Now project implementation
Effective
phase
date would be the date on which it is notified.
notified, right?
Correct. And go live is when the scheme comes into effect.
Notified till now.
No, according to us, it's not being notified. It's not even gone live. But we have
not gone live and then it's being implemented. But
yes, we are selling that bottles. Whatever price has been approved by the excise department in terms of the 12/9 notification, those new prices have come into effect. Those new price has been already incorporated. We are selling it. Obviously, we have not scanned it because the software and hardware has not yet come to us.
okay.
Next, my lord, at page 66, the stakeholders means all regulated and licensed entities working under the CEO and GOM, including the factories, wholesalers, retailers. So we come into here, my lord. Other excise licensees, excise department itself, and citizens for the state of Meghalaya. So everybody is inclusive as the state stakeholders. So everybody's measure will have to be taken before the implementation. Now, 1.1.27 on the same page, my lord.
Yeah, zero date.
Zero date or go live date means the date when the service and operation under this contract agreement starts. The service starts. The service is when everybody registers and you start scanning the bottle from the manufacturer, central bond house, bond, and then to the retailer, and then you sell it out to the customers. In terms of this, my lord, at page 71 is the price which has been fixed, which is in terms of the notification which will come subsequently. I'll point it out, my lord. Page 71. 5 at the top, my lord, payment terms. So it says
5.1.4.
5, yes, my lord, and 5.4 is what? 5.1.3 is that the company shall raise monthly invoices to the government as per the above clause in the subsequent month of rupees 240, which is the price fixed, and per bottle excluding GST and indirect taxes applicable, and billing date would be effectively go on the go live date.
Yes.
This is for the IEMS application. Now there is also a QR code annexed to the bottles. For that, a separate agreement was executed, my lord.
1 second.
Yes, ma'am. I'm sorry. Page 71.
So billing starts from the go live date.
Yes. So if it has gone live on 1st of October as priced to us by the Learned Advocate General on the last day, then the billing must have started and the scanning must have also started.
Yes.
Now, my lord, we'll come on the same affidavit, my lord, at page 88. So there are two parts of the scheme, my lord. One is the IEMS, one is the QR code, which has to be scanned.
Yes.
This agreement is executed in another private party, which is 3rd of July 2025.
Yes.
So this, my lord, is the agreement for implementation of the hologram, the scanning of that QR code, my lord. And at page 91 is the price and payment under the contract. 7.1, my lord, and 7. The price of the printed security hologram with QR code label shall be 1 rupee 50 paisa only per piece. The piece is inclusive of all applicable taxes.
So it's 1 rupee
50 paisa
code and 2 rupees 40 paisa for the IEMS.
Correct. So the government has yet to come out with any kind of an order to say actually that the scheme is this cost, but the agreement has already been executed. Insertion of 378 happens on 21st of January 2025. Now, after this, my lord, I'll go back to the writ petition again. And the first notification is issued by the government, which is 4th of August, my lord, is at page 55.
Or writ petition.
Yes, my lord, I go back to the writ petition. Because the dates are, we didn't have copies of this. This was only filed with the affidavit. So,
I think we'll need a
list of dates.
Compilation. I mean, it's like a consolidated compilation.
I will give it,
because if the notifications they go across.
The notifications are here only these two documents.
No, I mean it goes across.
Yes, my lord, I'll give it.
Yes.
So page 55, my lord. So the first time now, an order is passed by the Commissioner Excise in regards to the introduction of 378 and the scheme. So this is the subject is IEMS project implementation and go live. On this subject cited above, for smooth rollout of IEMS project, you are hereby directed to instruct, number 1, all bottling units, central bonded warehouse, state bonded warehouse, retailers to register in the IEMS application. All suppliers and companies to register in the IEMS application. All brand owners, companies to register to the cost of the IEMS application. The information is necessary for the compliance. So now this was first introduced on 4th of August. Subsequently, my lord, on 11th of August, another order is passed. Page 57. To desist to all bonded warehouse and retail shops, my lord. Again, the subject matter is project implementation and go live. It says, please register. We'll have to, otherwise your licenses will be cancelled after it goes live. So this is 11th of August, my lord. Okay. 4th of August. Subsequently, my lord, at page 65, for the first time on 13th of August, in terms of our documents that are available, this order is passed, my lord, at the bottom by the Deputy Commissioner Excise, my lord. This letter is for the first time introduces the price factor which is to be come up in terms of the scheme that is introduced. This says integrated excise management system application and matter regarding. This is references notification number so and so dated 23 January 2025, which means the insertion of 378, which I pointed out, my lord, in the counter affidavit. With reference to the above, this is to inform you that the department has signed an agreement with CMP Infosys LLP.
Is it the memorandum or what is it? Or the letter?
This is a letter. This is a letter introduced by the SSC.
Oh. Okay. Yeah.
The type copy is at page 66, my lord. So it says, with reference to the above, this is to inform you that the department has signed an agreement with CNP Infosys LLP for implementation of the IEMS with QR code labels for the state of Meghalaya. So those are the two agreements that I pointed out, my lord. One is in March, one is in July. In this connection, the department has fixed the cost of IEMS as ₹2.40, which is mentioned in that agreement, and plus GST, and the hologram cost is ₹1.50 plus 50 paisa as revenue component. So for the first time, a letter is introduced to bring in this cost price of the so and so. In terms of the agreement already executed, and in terms of the introduction of 378, insertion of 378.
Yeah.
Once this was done, my lord, our representation was filed at next page 67. This representation, the important paragraph is paragraph number 3, my lord. The representation says, however, there is an apprehension that among the retailers that with the introduction of the government's upcoming policy, there will be a hike in the MRP of IMLF brand, in which it will mitigate this by slashing the retail margin, which will be detrimental for the trade, and this will challenge the survival of the retailers in the competitive market. So the scheme now has been introduced. The price is now being introduced by an amendment, and they have now linked it by saying that this is the price for the scheme and the amendment is for this purpose. So the entire activity which happened for the insertion of 378 happened in the year 2024, my lord. So that is mentioned in the agreement. Subsequent to this, my lord, the order is now passed at page 76, the two notifications. Page 76, my lord. This is the 12th of September. There are two orders passed. One is 22/2025 of 28, and the other one is 22/2025 of 29. 76, my lord.
12th September.
12th September, page 76, my lord.
Yes.
Yes. The number of the notification is 22/25/28, and the other notification is 22/25/29. I am relying on both. One is the revision of the ad valorem and reclassification of the IMFL brands. So the prices are introduced. And at the next page, my lord, 79 is the notification which we are concerned. Page 79. And in terms of this, there is an amendment to 372, which is at page 81. The principal rule, that in Rule 372, Sub-Rule 1, for the clause of the following shall be substituted. The kind of liquors and maximum percentage of profit margin to be revised on retail sale as shown on beer so-and-so as 15%. So from 2017, my lord, till 2025, the prices were revised. The maximum retail price was incorporated in 2017 as 20%. Now
by this notification,
yes,
and September is reduced to 50%.
15%. And the reason we were linking with the scheme is to say that the process that has happened from that 2017.
So you want to lift the veil?
I would come to that by saying that
that is what you want to lift the veil, that there's no tangible, so you can't grasp it, but then the whole scheme was pointed towards that.
Yes.
That to facilitate this 5 rupees.
Correct.
So to add 50 paisa revenue, so that you're bearing the brunt. Correct.
Correct. And the reason I'm saying this also is, my lord, to the extent that your entire scheme that has been introduced was introduced in such a manner that there was no other occasion from 2017 to 2025 to revise those prices. Otherwise, I'm sure had been any changes in the retail price would have been obviously done. But from 2017 till today, till 2025 September, the only reason why this could have been brought in is because of the insertion of 378, by which all the other steps have followed now, my lord. So in terms of this, a cost card was also introduced. That's at page 83, my lord. Lordships are asking, how does the cost come into effect? This is 12th of September 2025, my lord. All bonded warehouse, central bonded warehouses, breweries, bottling units for state of Meghalaya. And then, my lord, at the next page 84, your lordships will give a format.
So in one day, all these things are put into place.
Yes.
With regard to cost card, the two notifications,
Everything.
reduction in the profit margin.
Everything. Now, my lord, here the format cost card is given. So what you do is, in terms of this implementation, this cost card has to be submitted to the department. The department will, whatever price that we give, the excise will have to then agree to that price, send it back to the manufacturer. They will incorporate the new price. After the new price is introduced, they'll have to fix the hologram, send it to the central by scanning. Obviously, the central has to scan it. It has to come to the bonded warehouse. They'll have to scan it. After they scan it, then it comes to the retailer. So I can only implement the scheme once the scanning happens. So for that, there is both a software, hardware, no cost paid by me.
Yes.
There's no cost paid by me. Now, in the same notification, my lord, I'll just go back to that notification once again at page 79. Lordships had asked about the central bond house.
Yes.
There was a statement meant that this money or this imposition is not just to one person. This has been unilaterally divided and perhaps given to everybody. Everybody has to share their part. And that was introduced at page 80 by amendment of Rule 44. So your lordships will remember there was a matter filed before this High Court where all the bonded houses had challenged, which led to the incorporation of the price fixation for the central bonded house. I will point out that order which has been relied by my learned friend in the affidavit, my lord. So that amendment is Rule 44, my lord. In the principal rules, Rule 44, page 80, my lord. I'm sorry, page 80, amendment to Rule 44. In the same notification, which is the 12th of September.
Yes.
In the principal rule, in Rule 44 of sub-rule.
Before it's 8%, it's come to 6%.
Yes. So 6%, 8%. So 6% is what is introduced here, 8% for the bond houses.
But bonded warehouse only enjoying 8% from before.
Yeah, 2017. This has only been introduced now.
And only
Central bond house was not before that.
One layer central bond warehouse has been given 6%.
Yeah.
Bonded house remained at 8%.
8%.
And yours will reduce to 15%.
Mine was reduced to 15%.
So
That
before
happened.
there was no central bonded warehouse. It was 8% for the bonded, 20%
20% for me. Then there was introduction of the central bond house.
House.
Yes.
Yes. So that's 6%. For
So when the matter came up before the court.
8% bonded warehouse will
No,
maintain.
it is not correct, my lord. What
Then?
it says that earlier it was minimum of 8% for bonded warehouse.
Okay, minimum.
No, and
Just
now,
understand 8%.
I just let me explain, my lord. Minimum means that the percentage could have gone beyond 8%.
We understand
But
that.
amendment has capped that it is a maximum 8%. Beyond 8%, bonded warehouse is not entitled. That is the difference.
Prior to there was nothing.
Prior, so that is the difference. We have capped their profit margin also. Earlier, they could have gone at any
To
rate.
cap profit margin, so you could give profit to the central bonded warehouse also.
No, that is not the case. What is being projected is not correct.
Observation.
Yeah,
Anyway,
your
let's
lordship-
not digress.
Yes.
And the issue ultimately falls for your lordship consideration is this much only. What my friend is crying or saying that my margin has come down. So therefore, I am entitled to invoke Article 226 to increase my margin.
Doesn't have, he can't invoke 226 in liquor.
That is the whole case which my friend is setting up.
My lord. So the amendment, my lord.
It's a privilege to trade liquor, not a right.
Right.
Yes.
So this amendment, my lord, of 44, which I pointed out, is in terms of an High Court order, which is that page relied by in the counter affidavit, the affidavit in reply filed by the government, my lord, at page 98.
Yes. International spirits and wine.
Yes, my lord. And at the relevant part is at page 126 is the directions that has been passed in this matter.
Yes.
The last 4 or 5 lines, my lord, are the directions that has been passed in this matter. The state government is to strictly monitor the business carried out by the central bonded warehouse with the other bonded warehouse and with the manufacturer, distillers and suppliers. By an administrative order, the state shall fairly and reasonably fix the commission to be charged by the central bond house. Fairly and reasonably. Next page, my lord, page 127. If it required, this extra amount of commission is to be first absorbed by the government by reducing its taxes on a bottle of liquor and therefore consider enhancing the price of the bottle, if required reasonably, so that the enhancement of price is minimal and it does not affect the commission earned by bonded warehouse or the market demand. So the liberty was granted, obviously not to the extent that you take away my profit margin. You fix it fairly, no problem. In this manner, my lord, what the government is now trying to do is, it's an indirect tax which they are taking my profit. Profit is my income. Can the government cap it by saying, no, your income of 20% was not right in 2017. Now we are going to cap your income to 15%. So when the government says that whether I have the right to come up, that protection, my lord, is only in regards to my income. Profit is income. Can the government do that? Can I invoke 226 to say to your lordships that yes, my right, qua profit, which is in the form of an excise to be given to a production or a manufacturer, is now been taken by me, from me in my profit, not on my sales. The MRP remains. They could have enhanced the price, they passed on to somebody else. No, they said no, it will be reduced from your profit. Profit which includes MRP, VAT, ad valorem, everything inclusive.
Right.
So that is what I'm trying to say, your lordships, that you can, but it has to be done in a reasonable manner. The word used is reasonable. The reason I said from the beginning
How
itself,
do you say it's unreasonable?
I said, your lordships, why? The moment you bring and try to cap my 20%, directly or indirectly.
See, the thing is that even if you say that capping away profit or taking away 5% is unreasonable, but the reasons behind it will maybe justify the reduction in profit, where across the board everyone's going to bear.
I was never taken into confidence also.
IMS and for the QR code, because it'll ensure also the the quality of the alcohol, spiritual alcohol is eradicated in the sense that the bottle is tracked from the place of manufacture or distilling to the bonded warehouse to the retailer.
Absolutely.
So the consumer who's at the end, who actually pays for everything, he gets a good product. That's all.
I agree, my lord.
But it might be alcohol, maybe anything else. But then that's the only thing. That's what we see. But you have to still satisfy this court.
Yes.
That what has been done, that 5% is totally unjustified and warrants that we.
What could be the other reason, my lord? From 2017, when the same price continues till 2025, till 2025 January, it's the same price, same profit margin. What is the difference and what is the reason why that was done? The only reason that I can justify from my record is there was an insertion of 378 by bringing in a scheme. The scheme says please pay 240 and 1 rupee 50 paisa and 50 paisa to the government revenue. If there was any other means, I am sure in the chain supply chain there will be other people who could have also been asked. Nobody's profit, nobody's thing has been touched. It's only who's been unilaterally targeted that you reduce your profit because 2017 was much more higher. Now let's bring it down to 15%. Whereas there has been in certain areas, my lord, where I have inquired from my clients, in areas like police, I think Polo, where initially before 2015 there were 17 shops. Now there are 42 shops. The license fees has always increased. The license fees has increased. I have put it in my rejoinder. Every year the license fees has increased. Which means, my lord, that my profit has also been affected. In the affidavit, they say there has been large amount of sale. There will be sale. Where there are 17 shops, there were 45 shops now. I'm sure the sales will increase. But what about my profit? My profit margin has gone down. The profit margin from 100 has now come to 70. And with 42 shops, it's going to further go down. Now, that is where it affects me. That is where my livelihood affects it. That is where I say that the income is affected. There was an option available for the government to pass it on to somewhere, but that was not done. I have been only targeted for this quiz. Now, in my writ petition, my lord, Page 15 of my writ petition. I'm sorry.
Yes.
Yes, ma'am. The writ petition, my lord, para 411.
Para?
11, page 15, internal, my lord. Page 15, para 11. My son.
Yes.
May I read, man?
Yes.
That the Deputy Commissioner Excise, Shillong, have also issued a letter dated so and so 13/8/2025. That's the letter I showed, my lord, whereby the cost of the IEMS system has been fixed for ₹2.40 plus GST, and the cost of hologram and QR has been fixed for ₹1.50. Further, it has imposed additional revenue component of ₹0.50. These prices per bottles and the initial cost is incurred by the manufacturer, bottle unit, central bond warehouses, and recovered while selling the bonded houses, who recovers from the retailers. This has resulted in increase of ₹4.40, approximately 5% of per bottle. These are additional rates and fees that has been introduced in supply chain due to the introduction of the IEMS application, leading to the increase in the cost per bottle. The respondent authorities could not have introduced the additional fees by way of a letter under 21 and 36. It is submitted that the respondents do not have the legislative competence to introduce a fee at a rate of IMS application for ₹2.40 and ₹1.50 and revenue of ₹0.50. Accordingly, the letter dated so and so is ultra-virus of the Act and unconstitutional. Now, my lord will now come back to page 17, para 12. The petitioners, fearing the introduction of IMES application and its exorbitant cost, which is also not a part of the government revenue, will lead to increase in MRP. And to mitigate the rising cost, the respondent authorities will unilaterally slash the maximum retail profit of the retailers without due consideration of other facts submitted in the representation of 2.9. So subsequently, my lord, after 23rd in 2021, I had given another representation which I had pointed out, my lord. Now, page 19, para 14. The commissioners, page 14, internal 19 page, my lord, para 14. The Commission on Excise, Registration, Taxation Stamp Department, in exercise of the powers under 36 of the Meghalaya Act, issued the notification of 12/9. By the said notification, Rule 372 was amended to the effect that the maximum percentage of profit margin to be reduced from 15 and existing 20%. This decision taken in the year 2017 to fix the maximum profit of 20% was after due consideration of all relevant factors that have changed only to mitigate the rising cost due to the introduction of the rate fees as stated above. While the changing of the decision, the respondent has failed to take into consideration the cost of living as well as the cost incurred on rent, salaries, license fees, electricity, transportation, etc. have increased over the year of 2017, and there is no justification or discernible reason to reduce it from 15% from 20%. Such decision is without any basis, as it has made the retailers to absorb the entire increase in cost, thereby throttling their business and pushing them to a closure. Subsequently, my lord, the deduction of the reduce of maximum profit margin by this amendment 372 is unreasonable and most arbitrary manner without any consideration of relevant facts. The respondent authorities have been able to act capriciously and arbitrarily only because of the fact that there is no policy, principle, standard for guiding the respondent for fixation of the profit margin. So the only consideration that they had was the introduction of the scheme. Now, my lord, para 32, page 30, my lord. The power to introduce, my lord. The petitioners submit that section 21 and more particular 36 of the Excise Act is invalid as it delegates unbridled powers to the state government to fix profit margin without giving any guiding principle or policy. Further, the Deputy Commissioner is not the appropriate authority to introduce such rate and fee at 21 under section 31 and 36 of the Meghalaya Excise Act, it is submitted that the respondent authorities, while issuing the letter dated so-and-so, have not exercised the power in a manner provided under the Excise Act, and therefore the same is ultra vires. Furthermore, the respondent authorities, in reducing the maximum profit margin of the retailers, have acted in arbitrarily, without any basis, and without even taking consideration of relevant facts. Such an impugn action will result in the throttling of business for the retailers and such effect the right of the business. The decision of the respondent authorities to reduce is perverse and overlook factors while fixing such rate. One more important factor, whether the profit margin is in consonance with the relevant market economy. That is what the High Court says in that order passed, which I read it out, my lord. The petitioners have been able to demonstrate that the margin now fixed is not sufficient to conduct the business, keeping in cost the license cost involved in business and rising cost of living. It is further submitted that such a decision without due consideration of the retailers have been made to absorb the additional increase in price and not being absorbed by the respondent or being passed on to the consumers. So this is in terms of that order direction that has been passed, which I read it to your lordships. In that they specifically said, if required, this extra amount of commission is to be first absorbed by this government by reducing its taxes on bottled liquor and thereafter considering enhancing the price of the bottle. That they have not done. That is an exercise they should have first done. Then they would have come to this. I could have still understood. And as a stakeholder, my lord, in the entire scheme that has been introduced, they have not even taken our consideration. There was nothing that was called. We were not even asked. This has been done completely unilaterally without any policy decision, nothing. The only thing that we can connect is the fact of the introduction of the scheme, which they have introduced. In regards to the allegation about alcohol and rest extra commercial, my lord, your lordships, on the last occasion, there was a reason said that this is rest extra commercial and whether certain benefits can be given to you in this trade. My lord, in one of the judgments, just one paragraph, my lord, I'm just remembering to go into it. 2024 assessment. I just I'm sorry, just one. Two. Just pass it on. Yeah, आपको जो भी एक copy है क्या? I'll just give it to you 1 minute. So the citation is 2024 SSC online Jharkhand 1075.
झारखंड ले आपने
Jharkhand 1075. आपको मैं देखता हूँ मेरे पास होना चाहिए. Lordship, please.
Yeah. This is Jharkhand.
Yes, that the judgment of the Supreme Court is relied here. That's how the part I want to read out to your lordships. That's at page paragraph 68, my lord. The two judgments of Supreme Court which is relied and distinguished. 68, madam. Yes, ma'am. May I just read? Justice Bhattacharyya has it. It is a well-settled law by several decisions of the Honorable Apex Court that there is no fundamental right to a citizen to carry on trade and business in liquor, and no one can claim as against the state the right to carry on the trade and business in any intoxication, nor the state can be compelled to part with its exclusive right to privilege to manufacture, sale, storage of liquor. However, it has been held in the case of Doanji so-and-so 1991 so-and-so that if the state has decided to part with such right and privilege to others, then the state can regulate consistent with the principles of equality enshrined under Article 14, and it cannot act at its pleasure and act in an arbitrary manner, violating Article 14 of the Constitution of India. The reason I'm reading this, my lord, is the licenses that the retailers are using.
I'm not sure. Yes.
The licenses which has been given to the retailers are licenses which the government gives us, for which we pay a license fee. The moment that happens, which is a derogation of the powers of the government, I get the benefit. And this benefit is only because then there is the equality that has to be maintained. Para 65, my lord, after that. 69, I'm sorry. Similar view has been taken by the Honorable Apex Court in the case of Kerala Bar Association and State of Kerala, wherein it has been held that the next ground of challenge under
Article
ISAT.
14 you understand.
Yes.
But then how does Article 14 come into
Yes,
present
this is
case?
what is been argued here, my lord. The next ground for the challenge has been Article 19. The learned senior counsel for the appellant, Mr. Aryama Sundaram, has sought to argue the Article 19(1)(g) exists in the business of liquor. It is detailed elucidation of the decisions made in Code has been contended the state is given three options. The first is prohibition, the second is the state monopoly, is manufacture and the trade, or both in portable liquor, and the third is, which is similar to the case in hand, is that the state allows private individual into this business. In the event everyone will have a right to partake in it, reliance has been placed. My lord will now come to next part at page the para 32.
Yes.
Sorry, para 31, my lord, of the next page.
Yes. Yes.
Code has also held that the right under Article 19(1) of the Constitution are not absolute, as they are qualified by respective clauses 2 and 6 of the Article 19. The business in liquor is further regulated in the rigors of Article 47. However, the categorization of dealing in liquor as a qualified fundamental right cannot be interpreted to indicate the right of Article 19(1)(g) does not arise. This is in line of the previous 5-judge decision of Kishan Kumar Narula, which has been previously discussed, returned the opinion that the citizen have a right to deal in liquor subject to reasonable restriction in the public interest. The 5-star hotels are given the right to deal in liquor. All the categories of hotels can claim on the ground of Article 19(1)(g), subject to the reasonable restrictions allowed under 19(1)(6). It is also contended that the restrictions imposed herein are also not reasonable. For various reasons, including the relevant material has not been considered, so the restrictions was arbitrary and unreasonable. The division bench, while returning the finding of the single judge, held that the relevant materials are not considered. We cannot assume that the government did not consider the report at all. The appellants contended the assumption of the materials were considered merely because nothing on record definitely said that they were erroneous. 32. We disagree with the submission of the respondent that there is no right to trade in liquor because it is rest extra commercial. The interpretation of Code put forward by Sundaram is, in our opinion, more acceptable. The right under Article 19(1)(g), trade to liquor, does not exist provided the state permits the person to undertake its business. It is further qualified by the articles of 19(6) and 47. The question is then is whether the restriction imposed on the appellants are reasonable. 70. In view of the judgment of the Honorable Supreme Court, it is thus clear that although no one can claim a fundamental right to carry on the business and trade of liquor, but has the state decide to part its exclusive privilege and rights to others, then the restriction of the state can be tested in the level of Article 14, 19(1)(g) and 21 of the Constitution of India. So my argument is this, my lord. The moment I come under your umbrella, which is the protection that has been given to me by a trade license, I come under 14, 19, and 21.
It depends on circumstances of each case. In this case, Kerala case is that the sale of liquor to the public is limited to 5-star hotels, right? And so it's a tourist state and deprives all the other establishments of selling liquor. That's why 19(1)(g) will come, and the thing is that now why should you only allow 5 stars? Like, should be across the board.
Even
so if they've given the right, I mean, for them to trade, I mean, they can't discriminate.
I'm only trying to say that the discrimination that has happened qua taking away my 5% in the entire supply of chain of business. So what has practically happened is
discrimination against the Central Bonded Warehouse and the Bonded Warehouse.
Yes, because
where their profits have remained intact.
Yes, because
but Archival General has been capped.
Yeah,
so that's besides the point.
That's besides the point. But
so we'll take away their 5% of the Central Bonded Warehouse.
I leave that to you. But all I'm saying is, my lord, if there is a discrimination, obviously the policies will differ. I don't know. He will be.
I don't know what I will say to that. Then spread across that 5% into the 3 entities. 3, 2, 1. Oh no, 3, 1, 2. Yeah. Yes, like my brother saying, you do King Solomon's justice. Reduce the profit across the board.
Yes, that they can do.
Yes.
I'll pass it on to
if we are going to
to fixing the
just
margin, my lord.
So fixing the margin.
looking at the judgment of division bench in the other related matter.
Yes, ma'am.
So if you talk about reasonableness, now that's the only thing.
Yes, ma'am.
But you still have not linked the IMS to yours. It's like a standalone. But of course, looking at it, prima facie, yes.
That's all I wanted to show your lordship, that prima facie from the beginning till the end.
Technically, like what you call it, substantially, no.
From the beginning till the end of 2025, my lord.
Because the intent and objective of that IMS is totally different. That they can totally
The scheme is independent.
Yeah, that is what the scheme is.
Scheme is independent.
But the linkage between now the reduction of profit, maybe you have occasionally there that it has been unreasonably reduced.
That's all my case is, my
leaving the
lord.
other entities intact.
That's all I'm saying.
Yes,
That's all I'm saying.
and that the logical link is that it is to facilitate the implementation of the IMS and PR
Yes.
code.
Yes.
My lord, yes, if my friend has concluded, my lord, if I have understood the argument, my friend, he says that he has fundamental right to maintain 20% profit margin.
No, it's a fundamental right. Is that
Yes,
a right has been given to him?
Yes, right has
which
been-
has been taken away.
So right.
So whether the
no,
taking
so
away is not something that he's asking for, it's something that he had.
So he
Now
so
he's had the 20%.
earlier what was the
Now he's taking away
percent?
5%,
No, earlier
whether-
what was the percentage he was getting? 15%. Now again it was increased to 20%. Now it has been brought down to 15%. That is so whether the question which falls for your lordship's consideration is this: whether any person has a right to profit margin in trade. Because that is the legal issue which that's a core issue. That's a core legal issue.
That's a given, yes.
Yeah, that's a core legal issue. If he has right, then he can make out the grievance against the state government. If he has no legal right, he cannot make out the grievance.
That means the state has unbridled and unfettered power
Yes,
to
for
impose
example,
any
Milord,
kind.
for-
Tomorrow they issue notification that the
Yes,
retailers
Milord.
profit margin
To 5%,
to 3%.
3%, 2%. My
can do it.
income tax, my lord, income tax is increased to 50% or 10% or 20%, my lord. Your lordship is aware that so far as the economic policies are concerned, the state has greater latitude.
Of course.
A state has greater, because why should I pay 50% tax, or why should one pay 10% tax, my lord? Whether those issues can be subject matter of judicial review, that is the issue which I am placing before your lordship's kind consideration.
Yes, I mean we'll have to. I'm sorry, but I'll have to sit with this Chief Justice for a bit. Then
Yes,
we'll
ma'am.
come and resume.
Yes, ma'am.
Sorry for inconvenience.
No, my lord.
Yes.
And this matter is pending in Supreme. My lord,
Not like
just check, my lord.
Not like Indigo. Hearing wouldn't be cancelled.
I just checked, my friend. This judgment is pending in Supreme Court, my lord. My friend should have.
Of course, it will.
Might be.
And that's
I'm
been
only-
disclosed, my lord. That has been treated as that not informing in one of the matter. That matter is pending and reliance is being placed. That has been
They're not-
treated.
I was not concluded.
I'll soon.
Thankful that he's reminded me. I'll check it.
Any mention?
Please, Lordship, I make a mention for listing this matter tomorrow, Lordship.
What matter is this?
This is matter regarding the petitioner agreed by the respondent for failure to act on the FIR, Lordship, filed against the private respondent.
Fresh case.
Yes, Lordship. All right.
Yes.
Supplementary list?
Yes.
May I please, Your Lordship. Lordship, I beg to mention item number 31.
Item number?
31, Your Lordship, from hearing.
You're there. 31.
31, Your Lordship.
Are there many mentions?
I'm not aware, Your Lordship.
No, are the lawyers for the hearings already taken up, or many mentions are there? You are mentioning?
Lordship,
Who all are mentioning? Whoever have matters want to mention today. Yes. Don't look so. Are you mentioning?
Yes.
You mentioned, then you do one thing. If you are consent, you just give in a slip and give to the bench, and we can start the other matters. Just give to the bench assistant, master. Okay, instead of one by one. And all the matters stand adjourned after vacations.
Lordship.
Yeah, and you just indicate that you just give it to the request is by petitioner or by respondent. Right? Yes.
Lordship.
Follow the list. Yes.
Supplementary list, item number 1.
You give it. Yes, you give the list. Yes. You mention.
May please, Your Lordship.
You give your and don't, please cut the charter down and just give your individual list. Yes, give your slips for your items. Yes.
Your Lordship, may please. Lordship, this is the matter that I've come. I crave leave, Your Lordship, to kindly take the matter under Article 227 of the Constitution of India. To exercise superintendence over the.
227?
Yes, Your
You
Lordship.
draw and file afresh then. You're going to go to another bench. Yes.
Your Lordship, Lordship, just simply the matter is determine the correctness of the order passed by the judicial magistrate or the extreme
If
magistrate.
that's superintendence over the subordinate courts, then
Your Lordship, the matter involved first of all was not heard on the entire whatever
see, if
proceedings.
you want to file a 227, correct?
Yes.
Or 226, you make up your mind.
If it takes,
226, then
yes, I'll go on to 227, Your Lordship.
then you withdraw it. You file it fresh.
Yes, Your Lordship.
Mr. Esalindo, Leonard Counsel for the petitioner, submits that as he wishes to pursue remedy under the Article 227, the initial petition may be not be withdrawn. Give it liberty
File afresh.
to file an appropriate application. So, not objected to by respondents, prayers allowed. The matter stands withdrawn, however, liberty is prayed. Yes.
Kindly obliged.
Item number 2.
Yes, when's the exam getting over?
Your Lordship, that is not yet
Now,
decided.
can you stand over till March?
Your Lordship, till the exams is over, Your Lordship. If it can be just mentioned till the exams is over.
Then we can't just hang it. We have to have a definite date.
We have not received the admit
Okay.
card also, Your Lordship.
But I think his child's mother is there. She can take it because he's staying quarter, I think.
For
Children,
now, for
yes.
now.
So you can retain the quarter till then, that's not a problem.
Yes. Then we will not entertain a petition then. Sorry.
Your Lordship, till the exams is over, Your Lordship.
No, then the mother will be here. They can retain the quarters only. Then he can pursue examination.
Because in the new posting place, Your Lordship, there is no accommodation.
No. I mean, for your son to finish the exams, he can stay here in the quarters.
He can stay, but the problem is the mother. She has to take care of the son as
How many
well as the
siblings
father.
does you have?
Only 2.
There are 2 children.
Yes.
How
And even
old?
the sister also, she's preparing for NEET exam.
Very difficult. How to put balance all that?
Need to resign and go.
Just
Come
some
to the
consideration,
next
Your Lordship.
Let it till March end. Yes.
But I doubt the exams will be over by March, Your Lordship.
But then you've got to build other arrangements, yes. When do the boards get over usually?
Because Your Lordship,
March gets over,
as per instruction, Your Lordship, even the last exams, it got finished by the month of May.
No,
Impossible.
Next admissions start.
Yes. I take down MS AP Kharsono submits that she has no definite instructions with regard to as to when the exams of the son of the petitioner will be over. Stop. If Dr. Muzika instruction submits that the only concession that can be made by the respondents is that
Kindly not record down.
oh, it'll be out of the court.
Well,
Dr. Muzika submits that he has no instructions and prays that the matter be disposed of accordingly. Yes, on hearing the on examination of the matter and considering the hardship that is being faced by the petitioner and his family, though not interfering with the transfer order, hereby allows that the quarters be allowed to we'll have to transfer till March and we'll sorry do not setting aside the transfer order. However, there is that the movement of the petitioner be effective from
15th of March. 15th of March is normally over.
Yes. Huh?
15th of March.
By 31st of March. By 31st of March. Stop. Till then, the petitioner is also permitted to retain his quarters, so that the exams of his child may not be disturbed. Yes.
But Your Lordship, if the exams
with the above, as ordered above, the matter stands disposed of.
Item number 3.
Your Lordship, the conducting counsel, Mr. S. Chauhan, is indisposed, so let the matter come up after vacation, Your Lordship.
What's the matter about?
It's,
Why can't you move in?
no such instruction, Your Lordship.
What instructions do you need? You don't have the brief with you? You don't have the brief with you?
I have, sir.
Then, what's the case about?
It's about not issuing the certified copy to the petitioner.
Where's your prayer?
Plot number
Certified
26.
copy of what?
Plot number 26, which is situated at Rinja RR Colony.
Land documents, Your
Land
Lordship.
documents.
Who are you? You're the owner of the land.
Yes.
You've lost your documents.
No.
You've
They are
lost your
relatives
documents.
of the landowner, Your Lordship. They are relatives of the landowner who has.
Let's take
since-
notice.
I'll accept notice. Sir.
Yeah,
All
MS
the
Arpol.
respondents.
Yes. Miss Arpol.
Yes. MS Arpol terms of the issue notice. MS that Enom can be his presence accept notice on behalf of
All the respondents, Your
all the
Lordship.
respondents. No further is required. This after lists after locations for necessary for instructions have been given.
Item number 4. Please, Your Lordship.
Yes.
Your Lordship, this matter pertains to appointment in lieu of the land donated by the petitioner, Your Lordship, in favor of the respondent
Land donated by the
petitioner. Yes, Your Lordship.
Yes. What land was donated?
For the expansion of the Tirot Singh Memorial.
Where's the agreement?
Agreement is in page. Agreement is page 23, Your Lordship, and the registered gift deed is in page 26.
23. 23.
And next year 6, Your Lordship.
23.
Yes, Your Lordship.
And next year 6. Yes. Okay. In that lieu application of the gift made of first party, second party shall accommodate and appoint. So they didn't appoint you.
No, Your Lordship. Here, Your Lordship, from the very first instances, if I may take Your Lordship to Annexure 3, which is in page 16, Your Lordship.
What happened?
Here, the petitioner has made it very clear before the respondent, Your Lordship. A meeting was held in the chamber of the Deputy Commissioner, Your
What
Lordship.
does it say?
It says that the petitioner will prefer an appointment in grade 3 post, Your Lordship, as per her educational qualification, Your Lordship.
Where is that? Lecture 3. Where is written?
Your Lordship.
Yes. The DMHO Nongstoin informs per government policy, only one grade 4 post can be given the plot of land donated to the government department. How this case to applicant post and appears the is yet to be legally registered. So it's been registered now.
Registered, Your Lordship. The registered.
What the qualification of the?
She was a degree in B Farm, Your Lordship. So an appointment later, Your Lordship. If she was offered, Your Lordship, an appointment, but in grade 4 post for the post of cook, Your Lordship. So which I refused to join, Your Lordship, because from the very first instances, I've made it clear to the respondent authority, but that I will.
But then government policy is only an unskilled grade 4 post.
No, Your Lordship, the government, as per the notification, it has in point 7, Your Lordship.
Let's see where notification.
It's a grade 3 or grade 4 post,
Where
Your Lordship. Your Lordship, I've not next, Your Lordship. I have a copy.
Why not next? Let's see. She's a B Farm.
Yes, B Farm, Your Lordship. Her
How much
degree
land donate? Area?
1,352, Your Lordship.
Square feet or meters?
Square meter.
Oh yeah. Yes, sir. You examine.
Lordship.
If she's qualified, then why not? If she and also is very good. She's a B Farm. It's not that she's a chef or something. Yes, I heard MSB student council petition issue notice. MS Digital Senior Government Advocate with so accepts notice behalf of all the respondents. All response, correct? No further call for stop. The grievance of the red petitioner is that pursuant to a donation of land to the government for the purposes of extension of the Tirat Singh Hospital, the agreement had been entered into for affording appointment to a nominee of landowner. The grievance as projected is that though the policy of the government allows for grade 3 and grade 4 appointment, the nominee do qualified, nominee stroke petitioner do qualified, has been offered grade 4 post of list application for instructional affidavit.
Much obliged, Lord.
Item 5.
Yes. Are you okay?
Please, Lordship. Lordship, is petitioner here challenging the impugn order, termination order dated 13 August 2024, my lord. This is by the JJTC. The impugn order was issued by the Secretary to the Executive Committee.
Where is the impugn order?
Lordship, that is page 31, Annex 10, my lord.
Why were you terminated?
The allegation against me was that I have associated with some political parties. That is the only allegation. But interestingly,
not true. You're not a member
no,
of the
I have. I strongly deny even in the Soko's reply, and also in all this one I have. I said
committee so and so have a terminate service of CISO for involved political activities and political affiliations. You're registered. Are you registered member of any political party?
He has ID. Lordship will
no,
see
Lordship,
previous page 30. Just the previous page at 30, my lord.
So what are you doing with an ID then?
Page 30. This was the inquiry report. Page 30, the second paragraph from the top. Therefore, the above, the copy of the ID, MPCC clearly. This is ID.
Page 30.
Lordship would see page 29. I'm sorry, 29. This is the report of the inquiry. Point number 1, my lord.
Charges
1, 2, and then again 1. It starts with the complainant produced he himself. This ID of this Meghalaya Pradesh so and so, ID number so and so.
Oh, you're a congressman.
Lordship.
Then how do you deny the ID then?
I have denied all this allegation.
Who made the ID in your name?
That also, to that effect, somebody has stated that idea is not within my knowledge, because it was admitted back, Lordship. Once my uncle was a politician, so I was a driver. So I went because he requested. Then when I dropped him, I just attend, but I have not registered. I have not registered. I just.
Then how do you have an identity card?
That even those identity card, everything, I'm denying. I stated that it's not involvement.
If that identity card on record, Then what is the rules governing
He has
government
not,
employees?
he has not
You
enclosed.
cannot engage in any. You produce an identity card. Let us see it.
Identity
Why is
card
it
actually that is their allegation, but actually it is not with me.
Forged identity card.
I'm denying that even the identity card
forged?
also. I don't have.
Is it forged or is it fabricated?
Because they are saying that.
No. What is your contention that it's made by somebody?
Yes, that is my
Mischievously.
contention, which I have not even.
Have you filed FIR? That in my name, someone mischievously
Lordship,
made me a congressman. Have you made that?
That statement I have made, but I have not filed the affidavit. They're not FIL, my lord.
That means.
No, I'm denying, and even the way the procedure or another ground is the procedure adopted by the.
You were given chance to be heard, correct?
No, there no official was appointed to represent my case. That's another one, and they have not even recorded all my statement, and there is no proper evidence has been recorded. Those are the procedures they are supposed to adopt it while conducting the disciplinary proceeding.
The fact that you said that I am a driver for your uncle.
Not driver means I was only asked only on particular day. My uncle only asked me to assist only for driving, not the regular driver.
You went drive for one day and you got ID card.
That is their allegation.
Possible?
That is their allegation, my lord.
We'll take notice, Lordship. This is in termination of last year, August.
Yes, heard Mr. P. Samba, Commissioner. Although the court are inclined to admit it anyway, issue notice, Mr. S. Deb.
For all the respondents.
All respondents. For the notice required. Just after locations for instruction.
Lordship.
Must you already have ID card.
Item number
You don't
6.
need any
Lordship,
verification.
that is their allegation, my lord. It's like
What allegation is your ID card?
His ID, he himself showed it.
There's a limit to shifting the burden.
Yes, Lordship.
It's the allegation. Yes.
Obliged.
Item number 6.
Much obliged, Lordship.
This is Assam Rifles matter, my lord.
Yeah. How many petitioners are here?
My lord, there are 23, my lord, petitioners.
What is the
And the initial trade in which they had joined service was nursing assistant.
No, what?
Nursing assistant.
What's the prayer remuneration?
Remasteration and payment of.
They've come under the same notification.
Yeah, under the same 97, 98. My lord.
Let them
But similar notice may be issued. My lord.
But Mr. Piram Nangdi, issue notice. Dr. N. Modika with MS Emerchang present on behalf of the respondents. No further is required. This after vacation for affidavit. Yes.
7.
Deeply obliged.
Lord, may it please your lordship.
Yes.
This matter pertains to, my lord, the VEC of Morasuti village.
Which village? Molokandi?
Morasuti, my lord. Morasuti.
Different village now.
Different village. Within the West Gallawas district. My lord, here the only grievance which the petitioner is seeking to agitate before your lordship is that, my lord, the term of erstwhile VEC expired in the month of February 2025, my lord. Since then, there has been no election till date. There has been no election, my lord. There have been many representations from our side requesting the concerned officer, my lord, to conduct election. That has been, my lord, outrightly not acted upon. And my lord, there are certain, I'll just take your lordship to certain annexure. The erstwhile VEC has done no work at all, my lord. Even though the amount has been sanctioned and released to them, my lord, literally on ground there has been no work. Therefore, my lord, since it relates to a public fund, the misutilization of public fund, my lord, we are also seeking for some inquiry in the matter. My lord, may kindly have page 38.
What are the pictures here next year?
My lord, these are the work which was supposed to be done by the erstwhile, my lord, VEC. My lord, may kindly see a page before that. Page 37, my lord, will see the amount has already been sanctioned. Payment made. My lord, literally on ground there is no work. And this.
Okay, just stick to your basic grievance. You see, there's no working VC here in this village.
My lord, there's no.
Who's running
the old VC is still running, even though, my lord, the term has already expired. But there have been representation from my side, my lord, requesting the concerned officer to hold election. That has been, my lord, completely ignored.
Can you get instruction by next week whether it's a VC or not duly constituted? I heard Mr.
But my lord, in the meantime, my lord will kindly see. First is the locus of the petitioners, my lord. Secondly, there they have made a submission, my lord, that there was.
Who are you?
There was an election.
I'm the job card holder, my lord, the resident of that.
And the election, my lord, they have said that it the
Where have they said that?
in para 13, my lord, of the petition.
Para 13?
Yes, para
What have
13,
they
my lord,
said?
page 15.
Yes, the petition state well response.
Reference has started in the foregoing was awaited from respondents to the utter surprise and shock of the petitioners and other job card holders.
Oh.
It was learned transpired that VC again reconstituted.
Reconstituted, my lord, without holding election.
Here he is saying this.
My lord,
this is an
kindly
allegation
see.
which is
My
made,
lord, kindly read further.
No, my lord, that is their contention.
No, we are aggrieved by this very action also, my lord. Without constituting the, without holding the election.
Your praise is expired since February 25.
Right.
There's been no elections.
Right.
Now, and then 13, you say there's been no.
This is contradictory.
Where's the next?
Not contradictory. My lord, that is what I'm saying. My lord, may kindly read further. My lord, I'll just read, my lord, five lines from the bottom, my lord. If I make you know.
Then where do you get information from that?
Exactly, my lord.
My lord, we got to know, my lord, when we filed this application, there was some caveat
Okay,
filed.
just get an instruction. Yes, heard Mr. S. Thapa, and on the petitioner issue notice. Mr. Kiwi Bhattacharjee accept notice on behalf
1 to 5, my lord.
1 to 5. 1 to 5.
1 to 5, 6 and 7 are private response.
On 6 and 7. 6, 7 and 6 and 7. Stop. No, the grievance of the petitioner is that there has been no elections to the Village Employment Council of Morasuti, Morasuti Village since the expiry of the earlier VEC in February 2025. However, in para 13 thereof of the petition, it's also been stated that the VEC already constituted by the respondent number 5 by notification dated 27/10/2025. As there seems to be some confusion,
without holding election.
That is their allegation.
Instructions to be received within 1 week. Yes, we'll list.
Only small prayer.
Let's list it on. Now is the 9th on 15th.
Let there be an observation, my lord, the interim would be considered on the next date. My lord,
You say February 25?
my lord, here what is happening is, based on that illegal
Yes, next matter.
Lord, can it be on 16th?
16, yes. Yes.
Please, Lordship. Mr. Shila's leading this matter, Lordship, can be taken up end of the board, Lordship. Is this in code 1?
Are you seeking any interim orders?
No, Lordship.
No, Lordship.
Then?
I'll accept notice.
But Mr. Arkak, what's the matter about?
So we denied in recognizing our village, Lordship.
We
The
wanted
GHDC.
creation of village, Lordship.
Creation of village?
Yes, Lordship. But we were never heard also during the time when the order was passed.
No. Creation of village means what happened was?
Our village was, we had a member settlement of 135 houses.
With whom?
In a locality, Lordship. We had presented to the EC saying that this is our number of people in a settlement.
Where's order of rejection?
3625, Lordship. Is that?
3?
Page 111 is there, Lordship. Page
See,
number
if you're
109.
ready with the matter, you argue it. Why?
Lordship, just 109.
If we're seeking interim orders, then maybe it's different. You might need. Yes. What does it say? 111, nothing?
109, Lordship. Apologies.
109.
They said that there's no proper boundary that has been allocated.
Your parent village is which village? It's a parent village of this.
It's not known, Lordship. Lordship, the history is.
One of our contention also, Lordship, is that the respondent number 3.
Doloi.
No, Lordship. It's a private respondent who is the administrative officer. Is related with the one of the neighboring villages. There's some sort of allegations of biasness during the decision making.
No, very good. Doesn't matter. Yes, that will be taken care of. The Doloi has recommended the creation of village.
Lordship.
Lordship.
It's a recommendation.
Then there must be some veracity. Yes, heard Ms. R. Karakangler, counsel petitioner. You should notice Emil Longpur is present and accept notice on behalf of
1 and 2.
MS Ars Imli is the administrative officer.
Lordship.
You made 2 and 3, the same person.
Lordship,
In personal capacity.
there's a new administrative
Okay.
officer in place.
Accept on
She's been
behalf of
transferred.
respondent 1 and 2, notice to go to the remaining respondents within 3 days. This list of publications for further orders of affidavit. Yeah.
Pleasure.
Item number 9.
Scan this quickly.
May speak, Your Worship.
Yes.
This is in the nature of a mercy petition, my lords. The petitioner had
Why mercy
applied to the Northeastern Institute of Ayurveda and Homeopathy for the postgraduate course in homeopathy, my lords. He's featured at serial number 1 in the merit list. However, a date was fixed
For
for
admission?
reporting. Yes, my lord. He featured at serial number 1 in the merit list. And he was supposed to report on the 2nd by 10 o'clock for the admission process. Here he was late, my lords. So because of delayed reporting, he's been denied admission. Those are the worst facts of my case. Admitted position, he was late by a few minutes, my lord. Now, my lords, I am seeking your lordship's consideration broadly on 3 issues. Number 1, I will show, my lords, that there is some sort of arbitrariness in the selection process. That's number 1. Number 2, he was not given an opportunity of hearing, my
If
lord.
you only selected and came number 1, why you agree with the selection process?
I'll just show lordships only with regard to the timing. The original prospectus had certain terms and conditions. This timing was introduced by a subsequent instruction. So I'm saying that to some extent is arbitrary.
Okay.
Number 2, I was not given an opportunity of hearing and I was dealt with quite harshly. And lastly, my lords, I deserve some consideration. I would request your lordships do that in view of his socio-economic background. Well, it's please see the prospectus first at page number 21. As for the postgraduate homeopathic seats, there were 2 seats were
Already a
allotted.
doctor.
Yes, my lord. He's finished his undergraduate course in homeopathy, and at
From the
page
same
22,
institute?
well, yes, from the same institute, my
institute.
lord. Yes, yes.
Okay.
Now, please see the third last paragraph, my lord.
Yes.
Out of 2 MD homeopathy seats, 1 is allotted to the All India quota, and 1 under the open Northeast category, which is reserved for candidates holding a PRC of any Northeastern state. So he's applied under the Northeastern open category, my lord. Now, as far as the rules are concerned, please see page 25. The schedule for the admission process was laid down here. Lordships will see the first table. So these are the programs and the tentative dates. Lordships will see the first program. Last date of submission of application, 25th of November 2025, up to 5 p.m. So within this stipulated time, I submitted my application. Then there was a next program for declaration of first merit list, that is 28th of November 2025. This is the day when the merit list was published. His name featured at serial number 1. And here they added some additional instructions. Then we'll see the first counseling admission, that is 2nd December 2025. There is no timing mentioned here, my lord. So this day when I reported a little late happened on the 2nd. Now please see the note appended to the important dates.
Yeah.
Serial number 1. Application received after the closing date and time will not be considered. So admittedly, I reported on the same date within the stipulated time.
Prescribed till 10 o'clock.
At the first one, my lord, in that same table, 25th November,
No,
5
where
p.m.
it says 10 o'clock.
That's by a subsequent instruction. I'm just coming to that now. I'll just acquaint your lordships with the rules. Then please see number 6.
Yes.
If any candidate fails to appear on the mentioned date of counselling, his candidature will be cancelled. Only a date is mentioned, no timing. Now, if your lordships then turn to the method of selection at page 27. Serial number 1, Lord.
Yeah.
Merit list of all the candidates will be drawn up based on AIA PhD. This is All India Ayush Postgraduate Entrance Test 2025. Yeah. Score rank conducted by NTA. Accordingly, candidates will be called for counselling in order of merit and can exercise their respective choice of subject according to merit and availability of seats. This is important. In case of absentee, the next candidate in merit will be considered. Then please see further down, number 8.
Yes.
to fill the vacancies arising due to failure of appearance by the selected candidates. A sufficient number of candidates from the waiting list will also be called for counselling, intimating their merit position in the order. Such candidates will have to appear for the counselling on the notified date at their own risk and cost. Candidates who fail to attend counselling medical examination on the notified date or who decline the available seats for allotment, or those who will not join the allotted seat on the date of admission shall forfeit their claim to the seat. So this has to be deliberate or intentional on the part of a candidate not to take up the candidature for the seats. So they are trying to only cull out people who are not interested in this particular institute. Now, my lords, the instruction that was issued was on the 28th. This is at page 46.
On 28th November.
Yes, my lord. Now, I'll come to page 46 first. My lords, please see page 47. This is the merit list. At the bottom is the last table at page 47.
See, 46. Reporting date and time.
Yes.
2/12/2025 till 10 a.m.
Till 10 a.m.
Hall, and is qualified by this.
Yes, my lord.
After which no one will be allowed to report on any.
So I'm just saying that firstly, he has merit. Now, this was an additional instruction which was issued subsequently, not part of the original prospectus. It introduces a timeline that I have to join here by 10 a.m. In case I'm not there, somebody else who's lower in the merit list will be considered in my place. So I would submit this to some extent is arbitrary because it is not contained in the original prospectus. There's no dispute about the fact that, my lords, my name features as serial number 1.
From making any clarificatory notification later on.
I would submit, even if they do that, then they can take into consideration what sort of circumstances I faced because I did not report on time. My lords, I'm just coming to that. I've already explained, my lords, I was traveling from Jhalupada. The cab that I was traveling in, it was suffering some mechanical failure in the brakes. I was late, coupled with the fact that there was unusual heavy traffic on that particular day. So I was making the trip all the way from Jhalupada to Mawdyang. That is one of the main reasons.
What time do you leave your house?
I don't have that. But anyway, what I'm saying,
I told you,
I can take that information.
Because if it's so important that you come to 10.
Admittedly, my lords, I was late. Admittedly, I was late.
Not asking what time you got up to brush his teeth. Just what
I
time you left
understand.
his house. Yes.
That's one aspect. Number 2, if lordships look at the instructions, again back at page 46.
Yes.
Serial number 2, it says the reporting date time is at 10 a.m.
So
at the seminar hall.
Now still existing.
Has
the seat been
so
taken
to
over
the our information has gone to the private respondent number 6.
So third party interest has been created.
I've already made her a party. I'm just coming to that, my lord.
Yes.
Please see, the reporting venue is the seminar hall of the campus.
Yes.
On the very day when I reached, as I was approaching the seminar hall, I was informed by a friend that this place had been shifted to the conference hall. Now, this conference hall is at a distance of about 250 meters. Number 1. Now, as I was saying, my lords, there is some arbitrariness because in the whole prospectus, there was no mention of any timing. Number 1, this was introduced by a subsequent instruction. Number 2, there are instances where the Honorable Supreme Court has come to the aid of these sort of candidates, my lord. I won't take much time. My lords will have one decision.
Now let's go on to this.
I, in fact, went to the website. There is no final merit list as yet.
See, Northeast PRC, okay. Okay, yes. But has this other candidate,
to the best of my knowledge, my lord, the classes were to start on the 3rd. She only joined on Saturday. That's the 6th. That's to the best of my knowledge. This is subject to correction, my lord. My lord, will just see there are 2 or 3 instances where the Honorable Supreme Court has come to the aid of these sort of candidates. My lords have that decision. This is a decision from 30th of September 2024. These are the facts, my lord. The petitioner is a meritorious student. He belongs to the scheduled caste category. In my case, I am from Tripura. I belong to an OBC community, my lord. He appeared for the JEE Advanced 2024 examination and secured a rank of so-and-so in his category. He was allotted a seat at the IIT.
The only excuse is that you came from Jalupara and the taxi broke down.
No, it did not break down, my lords. He did not drive very fast because he claimed there was a mechanical problem with the brakes. So admittedly, I reached the institute a little late. Then I had to make the travel from the seminar hall till the conference hall because the venue had been changed. That's one, my lord. So if your lordships will just look at para 6 of this judgment.
Yeah.
Let's have it.
Yes.
Counsel appearing on behalf of the first respondent has furnished to the court the login details of the petitioner which indicate that he was diligent in accessing the portal and did everything within his power to secure the realization of his admission. The petitioner logged in on 24th so-and-so at so-and-so hours on as many as 6 occasions. This evidently indicates that he was making earnest efforts.
Tangible proof that he had made efforts.
No, I am admitting, my lord, these are the worst facts. I did come late. I did come late, my lord. So just see this part. There is no conceivable reason why the petitioner would not have done so if he had the wherewithal to pay the fees of rupees so and so. A talented student like the petitioner who belongs to a marginalized group of citizens and has done everything to secure admission should not be left in the lurch. The power of this court under Article 142 of the Constitution to do substantial justice is meant precisely to cover such a situation.
We don't have 142.
I understand, my lord, but lordships have the power. In fact, my lords will recall in those MBBS cases as well, it has been held that the Honourable Court has the power to direct creation of a supernumerary seat. This goes on, my lords. We'll see the fifth line from the bottom at para 7.
How's the intake of PG students in this homopathy?
For this particular academic, there are only 2.
No, what's the intake? I mean, a normal intake in other years?
9 in Ayurveda and 2 in homeopathy.
Every year?
Yes. This year. Every year. This particular year.
Last year?
Started this year.
Ayurvedic. But this is homeopathy, right?
My lords, homeopathy. Is homeopathy content.
Yes.
So let us please see the fifth line from the bottom at para 7. A supernumerary seat shall be created for the petition if so required for the purpose of complying with this order, and no existing student shall be disturbed in consequence. The petition should be entitled to all the consequences.
Supernumerary seat, but you just take instruction.
Well, there are 2 aspects, my lord.
Yes.
Now, your lordship has seen page 46. It very categorically.
Sorry. One more question. By how many minutes you say you're late or hours?
So, my lords, I made a representation there. I've said 2 minutes, but I'm not giving him that benefit. It could be a few more minutes, my lord.
Only minutes?
Yes, just a few. No, not at all. Not at all.
Yes, yes.
Now, my lord, page 46, lordship kindly says, my lord, at serial number 2, very categorically it says,
So
my lord.
that, yes.
Reporting time, date and time is so and so at 10 a.m. at seminar hall, after which no one will be allowed to report on any grounds, my lord. My lord, what happened, my lord? 10 o'clock, you close the gate, my lord.
Close the gate?
My lord. And then whoever was there now, candidate at serial number 2 reported at 9:54. And since till 10 o'clock, the time of closing of the gate, my lord, no other candidate serial number 1 not reported. Now, if we still admit someone, my lord, there will be unfairness to this number 2 candidate also, my lord. That's one aspect, my lord. Second aspect, that they are entitled to monthly stipend of 75,000 rupees, my lord. And it involves a lot of financial expenditure. And as of now, we don't have any. There's no possibility of supernumerary post, my lord. Now, only option for him is to apply next year, my lord. He's an in-house candidate. Most probably he'll get it.
You're working there?
Well,
are you working in this?
No, I'm not working. I've just finished my undergraduate, my lord. I'm not working there.
Because out of 2 seats, my lord, 1 is reserved for Northeastern candidates, my lord.
And one's open.
One is all India seat. And it's for near students also. For near seats students also.
The all India seat is open.
It entails a stipend of 75,000 per month, which is paid to a PG student.
Yes, ma'am.
That I can always take consideration. If there's any financial implication which bothers them, I'll take. My lords, yes, I can take instructions. But just look at the second judgment.
I don't think, because the seats are notified and the number of seats.
It's MBBS, the same thing happens.
It orders the court, let him just not.
Lordships are aware.
He is required to give. My lord, but I'll take a case. When I go to admit my daughter, I reach 1 hour in advance, my lord. He's taking so casually, my lord. In fact, we reach a previous day, my lord, and inquire in the evening that where is the venue, where is that, we go and.
But I understand.
Everything, my lord.
Those are the first questions.
He comes very relaxed, my lord. But
No, it's not a question very relaxed, because he was only. I can understand if he came at 11 o'clock or something. But he was thinking the Indian Standard Time operates. So he came a few
minutes.
Nia
is slightly different, my lord.
Exactly. That is the thing. When you give time is,
we faced him with all these same hard questions, my lord. We are admitting these are the worst facts of the case. Please look at the second judgment. This deals with some very important aspects of law. Very important issue, my lord. I won't take your lordship to the facts. I won't take your lordship to the facts, my lord. Please come to page 6, para 8. The pagination is at the bottom, page 6, para 8.
Yes.
In the present case, after the results were announced, the respondent number 3 issued a press advertisement providing necessary information and dates for conducting interview and document verification of the successful candidates. The information with respect to the medical examination was also mentioned therein. While candidates are expected to act diligently in matters of public employment, however, entire onus cannot be casted on them for omissions on their part, which can be condoned. The said advertisement does not mention the consequence for non-appearance, intentional or otherwise, in the medical examination. The advertisement also does not provide an opportunity of hearing in case the candidates were unable to appear in the medical examination, which may be possible in case of exigencies arises. Now please see the next page, para 12. The appellant has qualified prelim and main examination and thereafter successfully appeared in the office of the respondent number 3 for both interview and verification of her records. It was only in the third stage where she was required to appear for the medical examination where she failed to appear. Should therefore the appellant's candidature be solely rejected on this criteria that she failed to appear for the medical examination, considering she has qualified all the parameters to check her suitability and merit. As a model employer, the state and its instrumentalities are expected to act in compliance with the equality principles as enshrined in the Constitution of India. However, laws that do not appear to be providing for equality and are non-discriminatory in nature do not have the potential to be discriminatory. I'll just skip this again. Please come to page para 15 in the next page. Yes. Para 15. Let's have it. In the present case, the instructions issued by the respondent number 3 prima facie does seem to be non-discriminate and must be followed in its letter and spirit, but we cannot turn our heads to ignore the thread of ambiguity that runs through it. This is in addition, this is important, my lord, to absence of any mechanism providing redressal in case a candidate fails to appear in medical examination. The appellant belongs to a marginalized community, being a member of the scheduled tribe, has already proven her merit by qualifying the prelim examinations, main examination, thereafter successfully appeared before the interview board and got her documents verified on time as per the schedule prescribed by the respondent 3. It is a case that from this beginning, this is not relevant. Please come to para 17 then. Medical examination is conducted to only assess the physical fitness of a candidate and their suitability for the job, and it is not an assessment on merit of the candidate. We therefore fail to understand why would the appellant intentionally omit to appear for medical examination and thus be punished so disproportionately as has been done in this case. Even if it is accepted that the appellant was negligent in not being available.
Intention anything. The only thing is that whether the respondents could have issued the clarification. Where's that regarding that 10 o'clock?
This is at
whether it's within
page
the power or not. Regarding your
46. So I would submit, if your lordships look at the prospectus, well, the idea, the very objective is to call out people who are not interested, not people who are late.
Page 46.
Yes, my lord, page 46. Yes. This is the subsequent instruction.
Instructions, yes.
Yes, but if
this
I have taken your lordship
of the selection process, correct?
My lord.
In condition of selection process, where the prospectus, where
no, prospectus is before. Yes, exactly. The page prospectus 25, is important.
Page 25, my lord.
Yes.
Please see page 25, serial number 6.
No, serial number 6, my lord. The table and below that there is a note, my lord, star mark. Any further instruction, updates or amendments regarding counselling?
Yes, yes, correct.
I'm not denying that.
Notified in the website only.
My lord.
No, please see number 6 and then read it together with number 1 and page number 27. They're talking about absentees, my lord. Please see page 27, serial number 1, the method of selection.
Yes.
They're only going to call out absentees.
Yeah, Dr. Muzika, you are representing whom?
Me,
the director?
Deputy director.
You don't let him obtain positive instructions whether cannot go in these circumstances.
My instruction, my lord, only one seat was available that has been filled up. And involves, there are financial implications of that.
Will not take any step.
No, that I will take instructions immediately, my lord. I said it is a mercy petition right from the start. Right from the start. I'll take instructions as far as that is concerned.
He's also not clear on.
No, I was not faced with this question. This is coming up for the first day today.
See, the thing is that now if it involves any, financial implications, where they have provision only for 2 seats with the budget, whatever.
I understand.
Right? Then it'll be difficult.
Correct. I'll come back with an instruction tomorrow itself, my lord.
Because on the face of it, okay, you admit you are late. It's not a question of you being not allowed entry into the venue or something like that. If you were not allowed or someone prevented you, or you're not. But only thing is that also there must be a redressal mechanism worked into this, into your notification also. Suppose I think there should be some grace time and
an accident. Somebody falls ill.
Admission process is like this everywhere, my lord. For any exam, my lord, any recruitment
you break your leg and you're finished.
Or MPSC exam, my lord,
which is why this judgment
he doesn't go and doesn't appear, my lord, that's over, my lord.
Which is why this judgment has come out. It's a very recent judgment, my lord, from September 2025.
He could not appear for the medical test. That is altogether different.
See, that amount same thing, because it's not a question of selection. It's a question of appearance. If it's for selection, there's different things.
It's for counselling.
Counselling is number 1 in the merit list. Then,
but he has to be there, my lord.
He has to be in the few minutes. You shut the door.
My lord, 10 o'clock, I placed.
He, of course, at fault. He
placed
didn't
a
take 10
document,
o'clock very seriously.
I placed a document, my lord, to kindly see that.
Well, so if the considerations is finances, I'll take instruction, come back tomorrow
It's
itself.
not only, it's not only finance, my lord. Just open it.
What is this?
This is not. Kindly see, my lord.
It's signed by 1, 2, 3, 4, 5, all at 10 a.m.
My lord.
No, we
Only one candidate is present, my lord. Number 2, Ankita Kaushik, and it's signed by all the members, my lord.
no, we appreciate that you stick to the time. It's also very important also.
Yes, yes,
My lord, we
I
cannot.
can narrate, a story.
Gotcha.
Like, there was when a lot of these companies had foreign CEOs in India. So then, there's one CEO that when you fix a meeting at 10 o'clock like this, then, the employees are stolen, this whatever in the management is stolen at 10, 12, 10, 15, 10, 10. So they thought that, it's half an hour. Like 10 o'clock means 10:30 by 10:30.
Gotcha.
So then he realized that, they are doing this. So one day he posted a notice that a meeting will start at 10:11 a.m.
They were still late.
tomorrow. No. Then these people received notice 10:11. So why 10:11? Something. So they all reached at before 10:11. He's saying that why has he fixed it at a precise time 10:11? He said, you all here. The things that every minute is important. So when I put 10 o'clock, I think it's general. I put 10:11, you all here. It's like that. We should have put it at 10:12 like that, no? Then you'll know like important, It's
So
like,
9:58, my lord, in fact.
yeah, 9:58, yes.
But this is a very important lesson for him.
It's for everybody, like when you respect time, it's like you respect
Absolutely,
others
absolutely.
also.
But
It's
the
not
only thing
thinking
is-
only about your own convenience.
Absolutely. He's in fact, he's going to lose an entire academic session, which is very important for medical students. Now, I'll just leave your lordship with that thought. Absolutely.
Like that, yes.
I'll leave your lordship with that thought. Just have some sort of leniency
Tomorrow.
towards this candidate.
But I can come back tomorrow. But the instructions are very,
whether he
very
forfeits-
clear and categorical.
Let the court decide.
Lordship.
Whether he forfeits his stipend.
Lordship.
But he come back in instructions with regard to whether there's any possibility of, if without stipend, you can accommodate a student. That's all.
But here, these supernumerary
And
seats, all
whether
directions of the
your
court.
rules allow for
But the
whether your establishment or your
But the seats are sanctioned by National Council of Homeopathy.
only 2 seats.
Well, there's
Yes,
notified number of seats. Sir.
Yes. Then how you make
Sanction
them
and
party?
notified number.
No, so Malus will recall in all other cases, MCI usually does the same thing. The courts give directions to MCI.
Yes. Heard Mr. S. and the council petitioner issue notice. Dr. N. Mozika is present on behalf of respondent number. Uh, 1, 2, 5.
But 2 is not Nehu.
2 is Nehu. Let's
1,
1, 3, 4, and 5.
3,
4 and 5.
Affiliated to Nehu, this institute.
Yes, my lord.
1, 3, 4, and 5. MS Ibra present behalf number 2. Stop a notice not to issue to respondent number 6. Presently stop. The grievance of the writ petitioner is that on being selected at serial in the merit list at number 1 to pursue postgraduate course in homeopathy in the institute of the respondent
Number 3.
number 3 on failing to be present at the stipulated time of 10 a.m. the said seat has been denied to the petitioner. It is submitted by the learned counsel for the petitioner that there was no substantial delay and that the delay also was due to unavoidable circumstances. Therefore, prays that some consideration be given by the respondents to accommodate him in the course. Dr. N. Mozika, learned ESGI with so and so for the respondent has submitted that the instructions being clear with regard to the reporting in time for counseling, and further it also having been provided that should a candidate be absent, the same would go to the next in the merit list. There is no scope for consideration. Further, it's also submitted by the council that only 2 seats are sanctioned by the, what's it called?
National Council of Homeopathy.
The Council of Homeopathy. And
one is All India seat and one is North East seat.
And as such, there is no possibility of accommodating the petitioner. Even a supernumerary seat is created. Supernumerary seat is created. Shwagata is first submitted that. So, that which carries a stipend of rupees 75,000 per month. And as such, there is no state is created. So, this court has considered the tribal submissions. And considering the fact that the delay is marginal, directs the respondents to give some due consideration and to obtain specific instructions as to whether supernumerary post can be created. The petitioners also to obtain instructions as whether he is
willing to forego the
stipend amount if a seat is if the respondents agree to creation of supernumerary post.
But this would impede National Council of Homeopathy.
It
is for them to submit before this on record whether they can create a supernumerary post or not. It's not in the hands of our institute.
If Lordship, I'll do it by hand today itself.
Yes. When the order is in the process of dictation, Dr. N. Muzika has also apprised the court that the necessary council, that is the
National Council of Homeopathy.
National Council of Homeopathy has not been implemented as a respondent, and that it is this council which would decide as to whether such supernumerary posts can be created.
National Commission of Homeopathy.
National Commission.
Is it Commission or Council?
Commission.
It's a National Commission.
National Commission. In view of this submission, the court hereby allows the petitioner to implead the National
Commission
for
Homeopathy
as a necessary party respondent in the course of the day.
By hand, my lords.
Course of the day yes, they'll type it out. On the particulars being furnished. This might be after tomorrow.
Lodge. Very grateful.
I don't think National Council of Homeopathy will be able to. The notice has to go to them. Their instructions are more important, my lord.
You get instructions. That is the important thing.
But our instructions are very limited, my lord. Until and unless National Council will allow supernumerary post, my lord,
the course is started. When is starting?
It started on 3rd.
If Lordship permit, if that is the case, I'll send it by registered post today itself. Speed post. I'll send it by speed post today itself.
To complete them.
So after that,
also permitted on the duly implemented respondent.
The matter comes on 15th, my lord.
Yes, list on 15th to be effected by today itself.
Lordship, highly obliged. Very grateful, my lord.
See, just think because of student, that's all.
Yes, my lord.
And sleep by 1 or 2 minutes.
Lordship.
It's a bit harsh.
Yeah, 1 or 2 minutes is their his submission, my lord. That is without any basis, my lord. We don't
I'm saying about giving the benefit of that.
CCTV footage of the time.
No, I can say it's many minutes also, but then it's not an hour or half an hour as well.
Yes.
Highly obliged, my lord.
10.
But we type on last time. Yes, that bit of huh? This is the yes. Where's the JHDC? MSM Merchiang. Where's the affidavit?
So my affidavit is on record. I have brought everything that I had to do.
The affidavit, copy of the affidavit may be served on us also.
It has nothing to do. I'm just brought in record my constitution, Lordship. Whatever.
They're just saying that they have nothing to do with it.
Yes. At least a copy should be served. They should know how they have passed that order. Very well, I'll give the copy, Lordship. I need to Xerox.
If you can give a complaint to them, ask them to close down the gate, at least you can give,
Absolutely,
they listen to you very obediently.
Absolutely, Lordship. I'll give it. I'll give a copy today itself.
Are you operating the lease? Are you still running?
Yes, yes, I am. There is a stay out also.
Running it, but the thing is that as per the report, whatever pictures they've annexed.
No, I have taken instruction. This is absolutely
mechanism
incorrect.
not working, but it's charging the trucks.
In other words, I have not done that. This was put up by the JHADC. It's a very old picture. There's no date and timestamp.
Yes, where's the affidavit?
I have filed a supplementary affidavit.
When you file it?
First
By next
next
week. Yes, sir. An additional affidavit has been filed by the respondent number
6.
To bring on record the constitution.
Office bearers.
Ms. Emelon, on behalf of respondent to 5, submit that affidavit on behalf of the respondents will be filed by next week.
Next week.
Yes. This certification is.
Obliged.
11.
Motion behind.
Lordship, here I'm the wife of the deceased
Yes,
employee.
Mr. Gurri, why you don't want to
I have received, in fact, after motion, this was listed yesterday, the first day. However, I received the instructions. My lord will kindly see as per, because he would technically fall under the NPS, my lord. But nevertheless, my lord, no account was opened. That is the problem.
But the thing is that
he did not apply for NPS, my lord. And within a period of, before anything could be done, within a period of
He
1
died.
year, yes.
So how do you address these kind of problems? This
This is a
wife
very-
has been rendered destitute.
It's a very difficult situation, my lord.
He was
Because,
he is appointed since 95.
But subsequently, he was taken under, that
Then
was under master role.
RCW from 2005.
Yes, my lord.
Then
he was taken in as RCW in 2005. My lord.
Then
Subsequently, in the
of
year
course, NPS
2000
whatever, he never subscribed to the scheme.
No. Subsequently, my lord, 2017, he was absorbed. But my lord, he did not
Absorbed as grade D.
Grade 4, my lord, peon. Yes.
Office peon.
Yes, office peon.
You file affidavit.
My lord.
Mr. Kivarji today submits instructions that the writ petition, the deceased employee, though regularized on 2017, had. When did he die?
2018.
He died on
Had
30/12/2018.
On 13/12/2018, before he could register himself under the NPS.
Yes.
So, he is allowed to bring the entire instruction and affidavit. Yes.
Lordship.
He is allowed the certifications.
Obliged.
But
Well-
how do you address these things? There must be some. You work for so long. Yes.
May it please your lordship.
What is you file objection?
Yes, Lordship, I have filed.
Lordship, the admitted fact is that if lordship kindly have a page 2 at paragraph 4, your lordship.
Of the
affidavit in reply.
Page 2?
Page 2 of paragraph 4, your lordship. So it is admitted, your lordship, that the chairman as well as the secretary, they are in that
Where that page 2?
paragraph 2, your
That
lordship.
reply over 6, 7, 8 affidavit of the
Lordship, yes,
state
lordship,
ex-chairman
yes.
petitioner.
Lordship, yes.
Only the
Oh.
ex-chairman, Lordship. Only the ex-chairman, he is the
He is the
school teacher,
teacher.
Lordship. Whereas
And
the secretary, she is not the teacher, Lordship. She is just a helper, Lordship. And she is not being paid
In
also.
what capacity?
Just because the school was run by a father, Lordship,
How was she
missionary.
paid?
She was not paid, Lordship.
He
Only
was not paid.
no, Lordship. She just assists the mission, Lordship, the missionary.
It's
Voluntarily, Lordship. They just pay like that, Lordship. But there is
she
no
survived.
such appointment or
worked
official
whole day.
post. No, Lordship. She just went and then just to help the father in that school, Lordship. But she is not holding any post, Lordship.
what about number 1? That means he's out.
Yes, Lordship. However, Lordship, in this the new VEC also has been constituted, Lordship, And these people are the members in the new VAC also, Lordship. The chairman, he is also a school teacher, Lordship.
The present VC?
Yes, Lordship. And the secretary also, she's working in the block office, Lordship.
Lordship, the fact remains that if Lordship kindly have the prayer and the writ petition.
No, what fact remains that the VC is a correct.
Lordship, what I would propose, Lordship, because that is the allegation that the BEC was elected on 5/9/2025 contains a teacher as well as a government servant. If that be and this committee has not been approved, Your Lordship. If that is correct, Your Lordship, Lordship will grant us the permission to hold will conduct a fresh election, Your Lordship.
Additional affidavit has been filed by the writ petitioner. Yes. Who's number 4?
The new chairman, Lordship.
The new
and the new and headman also, Lordship.
He is headman or?
He is the present headman, Lordship. He is the chairman of this
school teacher also?
Yes, Lordship.
You are a school teacher? You don't know whether your client is a school teacher or not? Yeah, Mr. E. Marbanyang.
Lordship, may I clarify, Your Lordship? Yeah. Lordship, he is the headman, Your Lordship. The person who has been elected on 5/9/2025 is one Shri Laustar Kharkrang, Your Lordship.
He is number 4.
He's the
president.
number 4.
See?
Yes.
Laustar Kharkrang.
Oh, yes. Lordship will grant us the permission, we will hold a fresh election, Your Lordship.
Mr. E. Marbanyang has entered appearance today on behalf of respondent for such notice is complete and all the respondent stuff. An additional affidavit has also been filed by the writ petitioner. And in the said affidavit, it is seen that the allegation, it is seen that the respondent, the petitioner number 1, was a school teacher. Still serving school teacher also?
Yes, Lordship.
He is a school teacher. With regard to petition number 2, it is stated in the affidavit that he is only a helper in the school and not a regular
not
employee.
holding any post, Lordship.
Not a regular employee stuff. Further, the affidavit has also further in the affidavit, the petitioner has made the assertion that the present newly elected chairman.
Yes, Lordship. Chairman and the secretary also, Lordship.
Secretary, so report.
Secretary, she is working in the block office, Lordship.
Is assertion been made that the new chairman is a school teacher and the secretary also is serving in the block office.
School teacher at Maukahiyar SSA UP School.
Maukahiyar SSA UP School, and the secretary
is working under the Soyong block office.
And the secretary is working under Soyong in the RD block.
Yes, Lordship.
Soyong. So, next, in these circumstances, immediately should I not AG praise that he obtained.
Lordship, let the matter be disposed of, Lordship.
We'll see.
We'll hold a fresh election, Your Lordship.
In this view, the matter, Mr. Initial, please am allowed to obtain instructions as to the allegations made. The new VCs function, the old VCs.
No, Your Lordship.
It's
yet to be approved, Your Lordship.
The same correct. The entire exercise that has been carried earlier shall be nullified and new elections be conducted by allowing only eligible candidates.
Lordship, yes.
To be selected. Yes. You also doubtful? They also doubtful.
Lordship,
helper, teachers.
But the problem is with the video, Lordship. They should not have approved, Lordship.
Yes, the matters are consent disposal.
Dispose, Your Lordship. Apply, Your Lordship.
13.
Yes.
May it please your Lordship. Lordship, we receive instructions, my Lord. There has been a break with regard to the mandatory 12-year period, my Lord. I'll just submit this document before this honorable court.
Oh, he is born here?
Born here, but he studied in Assam, Lordship.
So it doesn't matter, his parents are from here.
But this is what the report I'm getting from the authorities, Lordship.
Your Lordship, his grandfather is also from here, His parents are farmer, all they have voter cards. He was born here, and sometimes due to some unavoidable circumstances, he went to Assam for 2 years with his parents because his father is a daily wage earner, mother is a maid servant. So just because of 2 years, he has already been selected and his name has come out in merit list. I can give you the copy of that also. Your Lordship can just go
No,
through.
see, even the track, what they've stated here, he started nursery, KG, class 1, high school at Rambai. Then after he started Holy Child in Tamil Nadu, then he came back to Shillong, Sangora Pachala.
He passes,
Moprem.
yes, secondary
Then he
exam.
passed.
Secondary exams, everything.
Give some consideration.
Lordship, as per my instructions, my lord, even the birth certificate obtained by the applicant, Lordship, it was obtained in the year 2019, my lord, when he
But-
was born in 2004, Lordship.
But the date of birth
that
counts.
also
Your
born at
Lordship.
home.
They do not have the records in the PHC. So 2004 is born.
2004, Lordship.
2004, so
That was the cutoff year for maintaining the records by PHCs. Persons qualified, let him serve the nation.
And his name has come out in merit list, Your Lordship. So he's about.
Where the merit list?
Just go to page number 2, Your Lordship. I have highlighted with the highlighter. His roll number is this, Your Lordship.
Okay.
So he has been selected, and he is to report tomorrow along with the certificate, Your Lordship.
Tomorrow?
Yeah. Yes, Your Lordship. Last occasion, so I had submitted before the court. And just because he's already selected, now again his candidature will be cancelled just for 2 years.
But I'm under instructions, my lord, that he's
Of
not
course.
qualified for the certificate for recruitment.
Where is the prescribed 12 years?
Lordship.
That is continuous.
It has to be continuous, my lord.
That even for many children and many officers also wouldn't qualify for PRC, then it's what do for schooling outside.
Oh, that's the...
Yes.
There's no such.
Where is it?
So far, I've
picture.
gone through. I've done my research, Your Lordship. I found out that minimum number of years is 7 years.
Page 3. At page
It's not
3, my
five,
lord.
it's not
Page 3, paragraph 3, your lordship.
While a person will be deemed permanent resident of district emergency having resident with civil children, if he has resident in the district not less than 12 years with civil. Oh, this is different.
That's regarding to PRC.
This is staying in regard to service. He was born here, grandparents from here, parents from here. We'll pass orders, yes.
Lordship.
Your Lordship,
Now is the time, yes.
just one small request, Your Lordship, because tomorrow he has to submit.
Yes, we will pass. We will make allowance for that. yes.
by the end of the day today, if he
Yes,
gets
of
the,
course. Don't worry. Only that other matters will try to finish also.
they usually upload in the online. Your Lordship.
Yes.
So
Hearing done? Hearing. Which hearing is done? We won't take up the hearing. Just we finish the orders.
Much obliged, lordship.
all right, Your Lordship.
Daily item number 1.
Supplementary for you too, no?
Please, Your Lordship, I'm praying some more time to issue notice to the respondents.
You didn't take steps, why? We'll dismiss it now. Okay. You are MS Bielankoi?
Yes, Your Lordship.
Yes, submits due to inadvertence. Steps not taken. She pays for not for a 2 weeks time, take steps. Yes.
Right, Your Lordship.
2.
What?
May I please, your lordship. Lordship, we have filed our service affidavit regarding the private respondent number 3, your lordship.
In the course of the day,
We have already filed on 24th of November.
MS Rahman. The affidavit status has been filed indicating service upon respondent number 3. Stop. Only 3 respondents.
Your lordship.
How many respondents? 3 only.
3 only, your lordship.
Outside notice complete all respondents. What about affidavit?
We have filed.
Only
Also, we
5.
are fine.
Yes, list after 2 weeks for appearance of number 3. Yes.
3.
Obliged, your lordship.
Yes.
I'm appearing for the respondent.
Yes. Yes.
But there's a review file, my lord, only for a very small thing. If Lordship kindly comes to the order passed, my lord.
Page 26.
Page 26, my lord.
Yes.
Para 4, my lord. Having heard learned counsel of the parties and on consideration of the fact that especially the earlier orders passed in similar matters wherein this court had come to the finding that remuneration is not a promotion or a financial obligation, and that counting of service for financial obligation under SCPs would be from the date of remuneration or date of initial entry into service. But the present matter does not involve remuneration anywhere, my lord. It is only from the date of direct entry, my lord.
Then Mr. Chanda.
Yes, my lord, I have no objection to that extent.
Yes. Heard Dr. M. Mozika and the counsel of the petitioner. Stop. The limited prayer in the review application is only for correction in para 4 of the judgment, wherein the date wherein it has appeared at, this is at 1, 2, 3, 4, 5.
No, the entire para will be substituted. Entire para 4 is substituted.
Yes, wherein, Soma? No, is that in para 4, the words from the date of remuneration has appeared. Stop, doctor, he has submitted that as the case is not a case of remuneration, the counting of service can only be from the date of initial entry into service. Counting of service period from service. Stop. Next paragraph, Mr. M. Chanda, Learned Counsel does not object to the prayer made by, to the submissions made by the Learned EHGI. Stop. Accordingly, para 4 shall be substituted as follows. Quote, having heard Learned Counsel for the parties and on consideration of the facts and materials, especially the earlier orders passed in similar matters,
this sentence may be scored out whether the court had come to the finding.
No, we scored out with the matters.
From the date of date of joining, man.
Yes, it is directed that counting of service for financial upgradation under the APCP scheme should be from the date of initial entry of service by joining. So, close quotes. The above noted paragraph shall be substituted in place para 4 in the order dated. What is that? Order dated
6/6/25.
6/6/25. Stop. The review application only stands allowed and is disposed of.
People are like.
But the next is also similar.
Next also same.
Para 4 only. Yes.
Para 3.
Same thing.
No, the wording is different.
What's para 3 say? This is
page 24.
Same paragraph. For instance, para 3 shall substitute the early judgment. Instead of para 4 early judgment, para 3.
Yes.
And with the same wordings, substitute it.
And the order date is 17/2/25 in this case.
Item number 5.
Yes. Join the file. Yes, parties submit the experience complete. This is the matter for hearing after vacation. Is interim order?
No interim order.
6.
May it please, Lordship. Lordship, this is a pension matter, Lordship. respondents are yet to file the
Please,
affidavit.
Your Lordship, there's a direction for the petitioner to report to the Agriculture Department, Lordship, to sign papers so that pension papers will be released. My Lord, yeah.
Mr. H. Karanlang today has come with instructions that the petitioner is to report to his department for finalization of his pension papers.
I'll take instructions, sir.
Yes. A copy of the communication containing the same dated 4 December 2025 has been submitted before this court. We'll dispose it of.
Let me take instructions also.
Yes, the census is submitted, it's taken on record. This up next week for instructions to be received by the petitioner. You go and report.
7.
My Lord.
Yes.
Please, Your Lordship, the respondents are supposed to file their affidavit, and for respondent number 5, no one has appeared till now, Lordship.
Where's the 1, 2, 3? Not filing affidavit. MS Pasa.
I'll be filing, Your Lordship. I've
Was
received
already.
instruction. Lordship. No, Lordship.
When?
I'll be filing within a week, Lordship.
None appears on behalf of state respondents 1, 2, 3. Stop MSV Pasa present on number 4. Please follow up for a 2 weeks time for affidavit. Although it's stated that the respondent 5 since been served, there's no appearance on number 5. List of applications for further orders. Yes.
8.
Yes, my Lord. Here, my Lord, I'm appearing for respondent 1 to 7. My Lord, I did receive my parawise reply. There's some vermins, my Lord, which needs clarification. I've sent it back, my Lord. That's why I could not file my...
MS OI Bank submits as instructions were incomplete. Should be allowed for the 2 weeks time for affidavit.
I received instruction, Your Lordship. I'll be filing.
MS submits that. It goes over the day.
No, Lordship.
For a similar prayer is up to 2 weeks.
9.
Yes.
Let's go affidavit. I'm bring some more time.
Affidavit, man.
Allow them.
As a last term.
For the 2 weeks is prayer allowed.
I'll have it.
10.
May it please your Lordship.
Yes.
Lordship, this is that matter wherein the petitioner had inadvertently marked no against the question whether he's
Have you have authorities to show that it can be recalled, OMR sheet?
That it can, yes, your Lordship.
You got authorities?
That if there are mistakes in the OMR sheet, then the court can exercise its discretion to
Where
take a
is it?
merciful
Let's
view.
You have marked there that you're not a sports person.
Yes, your
correct?
Lordship. We admit
you
that. We admit that mistake, your Lordship.
So this is what authority we have to see.
Yes, your Lordship.
You read out. Give me a copy of whatever.
Yes, your Lordship. Just Lordship, this is a judgment of the Honorable High Court of Hyderabad. This has also been followed in by
Okay,
the.
yes, let's see what it says. Para.
Lordship, the relevant paragraph is marked. It's paragraph 9 onwards. May I read, your Lordship?
See, the thing is that it's not a question of marking the wrong one, or he forgot to thicken it properly.
Yes, your Lordship, I admit.
It did not.
Your Lordship, there's also a judgment wherein the applicant therein had marked no against the question whether they belong to the persons with disability category or not. In that case as well, your Lordship, as well as in other cases, when there's this kind of a mistake which has been inadvertently been caused by the applicant, the courts have taken merciful views. Of course, we cannot assert any right. We are only praying for this honorable court's indulgence. In fact, there's one judgment of the honorable Supreme Court as well. It was the mistake which had been made therein was with respect to the date of birth. However, the honorable Supreme Court noted that since the mistake did not lead to any benefit to the applicant, no malified intention can be imputed, and such
judgment.
Yes, sir.
Yes, MS Khanna, you ready for final hearing today?
Your Lordship, it would cause prejudice to, because there was one candidate who secured higher marks than the petitioner under the sports category, Hasi Jaintia. And that candidate was called for interview and did not clear. So if he was to be under the sports category, Your Lordship, then it would cause prejudice to...
No, but the selection said there's no one from sports category.
Exactly, Your Lordship. The person who cleared from the sports category, he cleared the written examination, but personal interview he did not clear, and he secured higher marks than the petitioner, Your Lordship.
Have you filed affidavit?
I filed, but I have not placed that on the court, Your Lordship. I'll just...
So we'll hear you another day. Yes, you are Mr.
A. Singh.
Mr. A. Singh has placed some authorities. So you give citations to the council also?
Yes, sir.
Yep. Suppose the matter for further orders on today is the 9th, on 11th. Yes. Also have it on
Lordship next week.
very pressed for time, yes, on 16th.
Grateful.
Highly obliged.
11.
Or Granel, yes, Mr.
Well, I have received the name of the new elected chief, acting chief. His name is Cortes Rani, Curtisrani.
Yes. So what are we to do?
I may be allowed to serve the notice.
Allowed to for some more time to find a counter.
Yes.
Lordship,
Kashi submits that he has
I may be allowed also to serve the notice to implement respondent number 6.
The new incumbent in the office acting name, Himanong Spung. He is allowed to empty the correct to
and also to respondent number 6.
To enter that in the court title and take fresh steps upon him.
Respondent number 6 as well.
Respondent number 6.
Historian.
On the said respondent, on the said new incumbent as well on the respondent number 6. The prayers allowed.
No, respondent number 6 is Torian War, my lord, which has been impleted in the last occasion.
No, 5 only impleted. Now 5 is the name you've got, right? For 5.
5 is
5 is the correct name you obtained now, correct?
My lord.
That is what. You're confusing not yourself but the court also. Yes, Omna? Respondent number 5, and prays that we be allowed to enter the same in the course title and to take steps upon the said respondent. So he also prays he will have to take steps on respondent number 6. Prays are allowed. Correction may be made in the course of the day in the course title. Mrs. C.T. Sangwa on behalf of respondent 124.
Wonderful.
Prays responds out further 2 weeks and file affidavit. Just applications for further orders. Yes.
Well,
hello, bless.
May it please your lordship, notice was served upon respondent number 6.
Where's the instructions?
Shall we receive instructions? She will require to file an affidavit.
What's the matter about?
It's regarding afforestation of Thatmanri forest, Lordship. Lordship, they say that
what are specific instructions you received?
Lordship, if you kindly come to the writ petition, Lordship, page 32. Page 32 of the writ petition. The type copy is at page 34, Lordship. Page 34. This is the agreement executed with the district council, Lordship. Now kindly see the boundaries, Lordship. North, east, south, west, river, Minken, Kangra Road, Mingsing Hill, Linda, forest land of district council, Lordship. Now kindly come to page. Kindly come to page 38, Lordship. Now, on the top, Lordship, Thatmanry is written. The boundaries is mentioned there, Lordship.
But it's a very old document. When was this made? In
71. This is an order dated 17/4/71, Lordship.
We'll examine it. Let them file affidavit.
File affidavit.
Mr. Imran Kapoor submitted as the instructions are detailed and voluminous.
Lordship.
The please be allowed to place the same on affidavit. Praise allowed. Mr. Akhtar Khan has entered appearance on behalf of the
Respondent 6, Lordship.
number 6.
Thatmanry village.
Number
6.
6, Lordship.
6 is
6 is the village, Thatmanry village.
the 111 respondents. What about the others?
The other ones are the inhabitants of the Thatmanry village, Lordship.
You've taken steps on all of them.
No, Your
Notice have
Lordship.
not been issued, Lordship.
6 is just the village itself.
Yes, Lordship. Notice has to go to them because they claim that they are cultivating broomstick in the Thatmanry forest, Lordship.
No, for the time being, we will not see. Number 6, you also you represent the Vaishnav.
Through the Vaishnav.
Yes, Mr. Number 6, please funds allowed. Also, time to obtain instruction to file affidavit. With regard to our respondents, the notice is still put on hold until the next date. Yes, because once you issue notice to them, by the time notice complete, the 2 years will be gone.
13. 13.
Yes.
And 13 will require to file an affidavit, Lordship.
Steps was taken, Your Lordship, upon respondent number 5 and 6.
Number 5 and 6. You appear 5 and 6.
Body entered appearance last year.
What about 5?
5 is the
delivered,
Dalai, Lordship. The Dalai.
Dalai of?
Natyam, Ilaka Natyam.
He's been served.
Yes, Lordship.
Yes, yes, though respondent 5 has been served, there's no appearance yet on his behalf today. How much time for affidavit? 2 weeks. Yes, Mr. Emanuel for 4, Ms. Harkrang for 6. Pray for allowed for the 2 week time for affidavit. Distance one service.
14.
Yes.
Manoj, of the last date on 26/11/2025, the State
Yes.
Council
Yes.
apprised that there is a final report already submitted.
Yes.
Lordship can record that close this proceeding because.
Yes, we'll close the proceeding. Yes. Mr. You are Mr.
Yes. Lordship is B. Kaushik, my lord.
Mr. B. Kaushik submits as final report has been served, final been filed. The matter may be closed. Yes.
Much obliged, Lordship.
Matters only stands closed.
May I just request to mention the date of the final report?
Yes. Final report which date?
Date is 23/11/2025.
Yes. Mr. So-and-so submits as final report has been filed on 23/11/2025. Nothing survives consideration. So, on submissions of the Constitutional, the requisition of only stands closed and disposed of. Yes.
Much obliged,
Yes.
Lordship. 15.
Good.
Yes.
Wait, please, Lordship. Lordship, I'm praying for some time to file the affidavit.
What about where's Garville's? Oh, sorry. I thought it's yes.
Let him file affidavit, Lordship.
MS Idahar for 4 and 5. You won't file affidavit?
No, Your Lordship. Not at
Yes,
this
please pause allowed for the 2 weeks time to file affidavit. Yes. Yes, there are options.
Hearing 30. 30.
Oh, is not Mr. Father? Yes. What's the matter about?
That is violation of Article 20, subsection 3.
20?
20, subsection 3.
Any urgency is matter?
Not urgency.
After vacation,
Okay.
yes.
Much obliged.
Yes, on the prayer public of party, this is a matter of vacation. Yes, we'll recommend, I think, early lunchtime by how many matter division bench? Huh? Okay. 2 matters only. Yes. Yadyan's matters.
Second item.
BB. No.
Jorabat. Silong Jorabat.
But Jorabat only submission of those written notes.
I will request some time.
At least you give it before the vacation, so so we can spoil our vacations by writing judgments. Yes.
Okay. Much obliged.
Ash, thank you. Sorry for the slight dislocation. Yes, where's is it possible to continue? Be possible to conclude the hearing today?
Yes, I can half an hour, 40 minutes max, 35 minutes. 30
That's what you always say.
No, I will try to, because my friend has hardly raised any issue, legal issue or factual issue, both. I must.
You see, he has not. Yes, Mr. Ghosh.
Yes, my lord, item 2, my lord, has to just reserve the order. The written submissions are all being ready and to be filed, my lord. It's there with my colleagues.
Yes, wait, that matter. We'll do one thing because where's Dr. Mozika?
I believe they are not ready with the written submission.
That is what, yes.
Yes, but my lord may reserve it. Let them file it within before vacation. My lord,
Lord,
reserve it. At least there will be a closure.
From the state we have filed, my lord, today.
Yes, MSR Gurung to Mr. S. Ghosh, counsel for the petitioner, senior counsel with so and so present and have filed their written submissions.
Lordship,
along with the pen drive, along with the digital.
Lordship, I am praying for a short accommodation, Your Lordship.
And Sankan also for the state also. MSR Guru, however, prays for further 1 week's time.
Lordship, Lordship, the written submission, Your Lordship, are in the process of being drafted, Your Lordship, and approval of the DGG also is required, Lordship. Because, Lordship, there are many submissions which is made by the petitioner council.
What can we do then? We have to.
First week of January, Lordship, as soon as the registry opens, Lordship will be filing written submissions.
Lord may reserve it. Whatever they have, they can't improve the case.
See, Mr. Ghosh, when we reserve it, the onus comes on us that we're sitting on the judgment.
Lord,
that's a problem.
The union should be kind enough to ensure that they do so. They submit it on time. Not
We'll post it on 17th. If they can't do it, then we'll fix it. Yes. Post the matter on 17th. Yes.
Very well.
Much obliged.
From the state, my lord, we have filed today.
And the other matter, where's the other matter, income tax, that we won't take it up today. Just inform the councils.
All right.
To switch to the other one. Yes.
Your Lordship has seen that the first argument of my friend, my learned friend, is, my lord, that this notification relating to IEMS and hologram is bad.
One second. Just let me take a fresh sheet for your submission.
Yes, ma'am.
Okay, Shafi, type the order book. Wasting your time here.
Page 66 is the notification, which is, your Lordship, kindly see the prayer first, because prayer will make things very clear, my lord. Your Lordship, kindly come to page 35 of the writ petition.
35.
Prayer A, my lord.
Yes.
Writ in the nature of certiorari ought not to be sued to set aside the impugned letter bearing number 13th August 2025. Now this, then your Lordship will kindly see there are two notifications which are under challenge. That is
13/8/2025.
13/8/2025 is at page 65, my lord. Page 65. And type copy is at 66. Because there are two different two distinct issues which have been raised in the writ petition, my lord.
Yes.
Now 66 is the decision of the government to apply IEMS at the rate of 2 rupees 40 paisa and hologram or QR code at the rate of 1 rupees 50 paisa, my lord. That at 66.
1 second. This is, yes.
Yes, this is the notification of 13th August.
Covers both QR code and thing, no?
Yes, this is the IEMS application.
And QR code.
Yes, this is the IEMS application and QR code, my lord. So far as an IEMS application and hologram, sorry, IEMS application and hologram, my lord.
Yes.
Now, lordship, kindly note one more factor. Hologram cost was always there. It is not a new cost.
Now it's inclusive 240 of hologram also.
No, the lordship will find that IEMS application at the rate of ₹2.40 plus GST and hologram with QR code at rupees
extra.
₹1.50. This hologram was there. Earlier also it was ₹1.05 in 2019. Now it has been raised to ₹1.50.
Hologram is a sticker?
A sticker that your lordship will find in the liquor bottle at the, it is like a seal. So that to stop the counterfeiting of the liquor, my lord. That is, that hologram was all along has been there.
Okay.
So therefore, to say that this is a new thing so far as hologram.
So GST. That means once IMES, that's QR code. IMES a fee.
Yes, IMES is ₹2.40.
Then the QR code affixation.
Yes,
that's
this,
150.
Yes, the hologram and QR code ₹1.50 and IMS is ₹2.40.
So hologram and QR code inclusive in 150.
150. Yes,
the entire excess is 50 paisa plus 240 plus 150.
Yes.
Nothing else.
Nothing else.
Correct.
Correct. This is the notification which we are reading of notification says. Now the issue what I am trying to point out, my lord, is that this is a policy or decision of the government to apply IEMS application and hologram. My friend has not questioned this policy. He has said that this is a valid policy, it's a good policy, it is a good measure.
Yes.
He has questioned this decision on the ground that the cost is being borne by me.
Yes.
That is the, and that cost is being borne because there is a reduction of margin from 20 to 15%.
Yes.
And I should not bear the cost of this new policy or new feature, my lord. Now, lordship, kindly see that there is an overall reduction in the margin of all players, my lord. Earlier for bonded warehouse, my lord, the margin was minimum of 8%, which has been reduced to maximum of 8%. Because 8% was a fixed margin and over and above they could have 10, 12, whatever margin. So there is a reduction in the margin. There was no margin of central bonded warehouse. We have now a fixed margin of.
That means fixed margin. They can't get more than 8%.
They can't exceed 6% because cost card will have the margin component. And thirdly, my lord, that they are not bearing this cost also. Why? Because this is completely misconceived. Ultimately, it will be.
It is a very important. Yes. Why you see that they're not bearing the cost?
There is no question because they are not ultimately retailer. The consumer is paying the cost. It is not coming from their pocket. Their margin is 15%.
Which you say they cannot question.
That I will come to that portion also by illustrating two example, my lord. So the simple case which should fail. This is a measure which they say it is a beneficial measure. It is a measure which benefit will consumer. It is a measure to stop the spurious liquor, my lord. So therefore, to say that it is against Article 14 arbitrary illegal, my in respectful submission is not correct, my lord. Now, so far as margin is concerned, my lord, your lordship has seen that overall margin has come down for everything. For example, every year there is an increase in the sale of liquor, my lord. So if they are having 20% margin and sale is increasing, so then they are getting more profit, 15%. If I take their argument, for example, 100 rupees is the price of the bottle and about 4 rupees it will be added to the bottle price will become 104 million. So there will be increase in the MRP. If there is an increase in the MRP, there is a possibility of less sale, but less revenue. So then they will get on 20% also they can get less revenue.
Okay.
Yes, these are market dynamics, my lord, because if the MRP of the MRP price is getting absorbed in MRP for all stakeholders, my lord, so therefore to say that this is a I am the only one who is bearing it is the retailer. You are not paying this 4 rupees. Only thing is that you say that my margin 5% reduction in margin, but if there has been inconsistent increase in the sale of liquor, then you cannot say that all the time I should have 20%, because ultimately it is the cost which is being borne by the consumer. And these decisions, my lord, policy revenue decisions, they keep changing with the market dynamics, my lord. Because there was no cap for bonded warehouse. It was minimum you have to take it. They could have 10-12%. And this is a maximum, means even the bonded warehouse can negotiate with the retailer that look, you are for increase in the sale, your lordship has given the example, I give you 4% discount. So these are interplay of market dynamics where your lordship has in Article 226 has not intervened or interfered. Because they have to test their case on the parameters of constitutional and violation of fundamental right, violation of some statutory rights. Now, one point they have, so this is on the first aspect of the matter, because this policy is perfect, my lord. There is nothing wrong with this policy, and they cannot question also, my lord. Now, coming back to notification, my lord, the second prayer. If your lordship will see second prayer. There are two notifications which are under challenge before your lordship, C and D, at page 36.
Yes.
A writ in the nature of certiorari ought not to be issued to set aside the impugned notification of 12th September 2025.
That is.
Yes.
308.
Sorry, so impugned, this is the B, my lord. In the certiorari not to be set aside the impugned letter bearing number 12 September 2025, and C, ought not to be set aside the impugned notification dated 12/9.
Yeah,
so now these two notifications your lordship will find. The important notification is C, my lord, which is at page 81. So page 79.
C,
my lord. C is at page 79.
And the other one, B,
is at my lord, that is at page 83. And your lordship will find the Meghalaya Excise Amendment Rules at page 79.
Yes.
Page 79, production of non-alcoholic malt beverage within the brewery premises, etc., my lord. And then on next page, amendment to Rule 44. That is probably under challenge. They have challenged the entire notification, but they should have confined it to the 12 only. Entire notification there is no grievance against the other part of the notification. But in prayer, the entire notification is under challenge. But the grievance which has been ventilated before this honorable court,
yes,
is in respect of page 80 and rule amendment to Rule 44.
Whose phone is that? Not mine.
your silent ringtone is louder than the normal ringtone.
My apologies.
I thought my phone. I was looking for my phone.
It happens sometimes. Some phones, that vibrator. I mean, the vibrator's ring is louder than the normal ringtone. Yes.
So in page 80, the maximum profit margin for your lordship may kindly see. Yes. Central bonded warehouse on their sale to bonded warehouse shall be 6%. So there was no margin earlier.
Because there was no central bonded warehouse earlier.
No, before the central, if your lordship will, central bonded warehouse came in 2019. Kindly see this, the date. Yes. 19, when policy came, which was challenged before the division bench also, my lord. This was the grievance that there is no market, etc., no margin. So there was some committee, and then ultimately it was fixed. After 4 years, this margin has been fixed.
Yes.
So 6% are subject to maximum profit margin of ₹50 per case, and for bonded warehouse on their sale off and on shall be maximum profit of 8%, are subject to minimum of so and so, beer so and so.
So central warehouse is different. One is sealed to one house. shall be 6%.
Yes, I should take your lordship.
Say is maximum.
No, your lordship will see here it say maximum profit. First line, maximum profit margin.
Okay.
Maximum profit.
Also, minimum profit margin 65.
Yes.
And bonded warehouse and the maximum 8%.
8%. Yes, my lord. 8%. So the maximum and previous notification, if your lordship will see 2017 notification. Where is that notification? Sorry. The previous notification is in counter affidavit.
Page 42.
42.
In their affidavit.
Yes, my lord. In
additional affidavit.
Audit petition, page 42.
Yes. Now this is relating to. I wanted to show the bonded where because there was no profit margin at all. We have fixed the under the policy also, my lord. This margin has been fixed. But your lordship, for time being, kindly come back to the notification again at page. This is also not challenged. They are not challenging this 44 because it is for central bonded warehouse and bonded warehouse. The challenge, if your lordship will see, at page 81, 372.
Yes.
81. Maximum percentage is 15%. So what they say is that I have a right in law to maintain the maximum percentage of profit, which was 20%, and it is affecting their livelihood.
Yes.
And they were trying to argue that because of this IAMS, their margin is the only margin which has been impacted.
Yeah.
That is also not correct, my lord, and factually it is not correct. My lord, if I have to plead before your lordship in the writ petition, I will show that when I was getting 20%, I was having 100 rupees or 1000 rupees of sale. Last year this was the sale. This year this was the sale. This because of cost, because of this margin, I am losing this much amount, my lord. Whether your lordship will go into all these aspects in exercise of extraordinary jurisdiction or 226, but I have to demonstrate before your lordship that these measures will have this effect on my rights. There is nothing in this entire writ petition except that I have to bear the cost, my lord. It is mere ipse dixit. There is no material whatsoever. If your lordship decides to examine this aspect also, my lord, your lordship will have to see whether it is whether you have a right to livelihood in liquor or not.
And whether the direct effect, or direct consequence of the IMES, that is 5%.
There is nothing. There is no
touching the other margins.
Yes.
What you say, the other margins have been touched also.
Other margins have also
down
been.
The line.
Yes,
one has been touched.
Every margin has been touched,
So
and for the sake of argument,
8%. That means they also are losing out on the revenue.
They are whether they are losing out on revenue is also very debatable issue, my lord. Because
not them. I mean,
if I add 2 rupees 50 paisa in MRP, then the sale of the liquor will go down. Then they will have less margin. They will have less profit in 20% also. Because this is all market dynamics, my lord, to come out and say that there is a direct linkage of introduction of new scheme cost which is to be borne by the entire chain, which will affect the margin of theirs. Because if I increase the cost of the liquor by 10 rupees, the sale of liquor may go down, and then you will, even in 20% margin, you will have less revenue, less earning.
Okay, that's all hypothetical.
Hypothetical. Now the ground, my lord, which I wish to place, my lord. Now your lordship has seen these rules. Now what is the ground? These are all delegated legislation under the statutory rules, my lord. You have to show that, look, this is against the ground on which you can challenge the delegated legislation is it is violative of the statutory provisions, and I do not have power to amend the rules, my lord, because you are challenging the subordinate legislation. And the one paragraph your lordship will see, paragraph 13, my lord, where in the writ petition the pleading is there. If your lordship will kindly come to the pleading part, which was read out also, my lord, saying that it is Article 14 and 21 is bad in law. Where is that line?
Where 13 is not.
40, sorry, 22. Yes, 14, my lord, sorry. If your lordship will see 2-3 paragraphs only, because ultimately whatever case is there, paragraph 11, my lord, at page 15. They say, my lord, in the 16, after 5 lines from the top, this has resulted in increase of 4.40% or approximately 5% per bottle. My lord, 5% per bottle, 200 rupees, 1000 rupees. It is all vague. These are additional rates fees which has been introduced in the supply chain due to introduction of IEMS application. Leading respondent could not have introduced the additional rate by way of in terms of section 21 and especially section 36. Respondent do not have legislative competence to introduce the fee rate of IEMS or so and so. So what they are saying that I do not have legislative competence to do that, my lord, because that is the only way they can non-suit me or get the legislation struck down by this honorable court, that I do not have power to do that. If I have power to do that, then your lordship knows that the test is not the basis, and then your lordship will see the basis is in the writ petition itself. Your lordship will see paragraph 14. Paragraph 14, your lordship has seen that it was reduced from 15 to 20%. 17, it was the rate was this. Now the question which is they are asking before your lordship is that whether we can change the rate or not. And paragraph 14 where say that it is violative of article 14, my lord. Paragraph 16, page 22.
The only thing which prima facie we see is that 15% will reduce, so that with the imposition of IMES, the rate will be affected for the consumer, and the consumption or the sale remains the same. That is the the business model of the state. That's the business model. I mean, the entire thing, if you see, it's like suppose you're sitting as a CEO of a company.
Yes.
And you're evolving a business model.
Yes,
that's the thing. And so, like, how
do I adjust the cost? Where do I adjust the cost, Miller? Your lordship is right.
But doesn't infringe.
How do I adjust the cost? How do we now?
Yes.
They say, my lord, that if your lordship will see paragraph 19 at page 25. Again, it is humbly submitted respondent could not have introduced additional fee by way of impugned letter, and section 21 and 36 of it is submitted that authorities do not have legislative competence.
Why did he say that?
Paragraph page 25, paragraph 19.
Yes. Yes.
And then your lordship will see ultimately they concede that under 2136 I have a power to do that. That they say in 23. Section 36 of 23, paragraph 23, page 26. The section 36 of Meghalaya Excise Act suffers from excessive delegation. So then 24, section 36 of Meghalaya Excise Act gives uncontrolled and unrestricted discretion to the state government to fix maximum profit. And then 25 finally, my lord, page 27, paragraph 25. Section 21 and 36 of Meghalaya is unconstitutional as entrusts the primary function of duty without any legislative policy. So the challenge, thrust of the challenge is to section 21 and 36, my lord. And where is the challenge of the statutory provision in the writ petition, my lord? So my point is, my lord, my submission is that under section 21 and 36, I have a power to fix the margin. you say yes, you have a power to fix the margin and you have power to but they say that it is a case, this section is unconstitutional. Where is the prayer, my lord? Where is their case? So if I have power to make law under section 21 and 36, my lord, Meghalaya Excise Act, and under Excise Act, Meghalaya Excise Act 36, we have the power to do that, and they are also conceding, but they say that it is a case of excessive delegation, my lord. Lordship, kindly have Excise Act 36. So I have completely failed to understand that I have power under the Act to fix the price, amend the rules. Then it is within intravires. It is within. Sorry.
Is that act with all the mistakes, correct?
This is going on from 1908, my lord.
The mistakes?
No mistakes. Some amendments are. This is 1910 Assam Excise Act, if your lords will see, and probably. And kindly see only one provision, my lord. I will not trouble your lordship with the section power of state government to make rules, my lord. 36. And
where's the parent act?
Assam Excise Act. Yes, yeah. Because your lordship will have to test their case on the anvil of my power under section 21 and 36. 21, 36, they concede that I have the power. In one line, they say that it is a case of excessive delegation, my lord. But that will not be sufficient to challenge the statutory provisions which has stood the time of more than 125 years. The state government may make rules for the purpose of carrying out the provisions of this act or any other law for time being in force in relating to excise revenue, my lord. And then your lordship will see.
Yes.
G, my lord. Regulating the period for which and the person to whom license for sale of any intoxicant may be granted and provide for selection of sites and shop may be opened. Prescribing the procedure to be followed and matters to be ascertained before any license such sale is granted. Prescribing the case of any intoxicant, the manner in which duty on such articles shall be. Prescribing the sale of fee or the manner of fixing fee payable in respect of any privilege, license, permit or pass in respect of storing of it. So all these powers are very much under section 36. They concede, but they say it is a case of excessive delegation. Now, K, my lord, prescribing the time, place and manner of payment of any duty or fee. So all these powers, the rules, your lordship has seen those amendments, my lord. The main challenge, I will say that the main challenge is to the rules at 372, my lord, at page 81. Yes, ma'am. So the 81, my lord, 81, and the challenge thereafter they have also given to the cost card at 89, my lord, because both the things you lords will have to examine. So the cost card is, they are saying that they strike the cost card also.
What is this retailing lifting fee?
Because there is a transportation fee, my lord. They lift some breakage is also there.
So who charges the fee? You charge the fee?
I charge the fees, my lord. Everything is with the component, because I asked for all these notification. If your lordship will see, because I was also a bit confused about this. This is because this is the way the liquors are registered here. In fact, all states in India. This is the process through which it is done. if your lordship will see submission of it goes to the manufacturer, my lord. Submission of renewal, registration of brand name and labels of IMFL wine, beer, BIO for the year 21-22. With reference to subject side, I am to inform you that application of renewal, etc. For 21, you are hereby directed to submit your application along with the following information so as to reach the office undersigned before so and so date. Brand name, label, alcoholic strength, bulk liter, number of bottles, LPR, country of origin, name and address, category, local production, import from outside, a comparative cost card of neighboring state, cost card reasonable and comparative as against serial number. Cost card, your lordship, this is the cost card which it as page 89. So all these factors go into the fixation of price of liquor in any state, my lord, not in Meghalaya. In all states, this is the practice they follow. So therefore, to say that please strike down the cost card, if the cost card is struck down, my lord, I have got 6% margin for central bonded, 8% for bonded warehouse, then their retailer margin, and under the rules within the powers we have done it. Okay. And then, my lord, most because first I have to satisfy the conscience of the court, my lord. First, my lord, these are all policy decisions of the government. And a scope of the interference in these matters under Article 226 is, in my humble submission, very narrow, which your lordship has laid down time to time. In fact, yesterday only judgment has come from the Honorable Supreme Court on directly on this issue, that in these matters there was the municipal authority fixed the rate for property tax in the house. That was challenged by way of PIL. Supreme Court said that you can't do it. These are the matters, revenue matters.
So it is a matter of revenue matter, so
yes,
without any
restrictions.
reliable index.
90
any
earlier,
amount.
your lordship would remember during around 30, it was income tax was 80%, 90% in the highest tax bracket, and there was, because ultimately there has been, it is never tested on the anvil or touchstone of Article 14 and 19. So to say that this now, your lordship, kindly see, because I would not trouble your lordship with everything in my count. I will take your lordship to the points in counter affidavit, so that will shorten my argument. It is like my notes only, my lord. Because they have not answered my preliminary objections also. There is no answer to my preliminary objection.
One thing, Mr. Foucault, regarding legislative competence, you have not made any substantial.
No, that's not my case, my lord.
No, you have said it, but you have not substantiated that.
I have not challenged 21. I have not challenged 36. That is not my case. My legislative competence is only to the extent of the introduction of the 20% to 15%. Para 19 and 20 is the submission that has got. So 21 and 36, my lord, I have not challenged at all, because that is the power in which 2017 was amended, right, and 2000 and also 2025.
Yes.
But 19 and 20.
It doesn't mean that if the notifications suit you, you're happy. It will suit you.
No, my lord. No, my lord. All I'm saying is that your powers in introducing a fees like this has to be made in a manner which is not arbitrary, because I stand under Article 14 and I get the benefit. It has to be treated in equilibrium. You cannot treat me separately. Therefore, I say Article 14, and therefore I say that the introduction of the price is bad. That's all. I'm not saying the scheme. So that has not been my prayer in any way. 14 and 19 and 20 are my paragraphs to that.
First thing, my lord, I raised the objection as to the maintainability of writ petition. Your lordship will have paragraph 7, my lord, by association. Because this
by association, now you come to that now. You should have been taken up first.
No, because that issue is because I have to satisfy that we are doing it. My lord, your lordship's power is wide, but ultimately they have to meet the basic thrust preliminary objection, my lord. Why I say so, my lord, that this is the association which has taken up the matter. Now, when I raise this objection, that association has no power to take up the grievances of individual members, because it is the grievance of the individual members that they have to pay. They are earning less.
Yes,
they are earning less. The division, the full bench of the Allahabad High Court, my lord. This is the judgment I have quoted at page 3, my lord. Full bench of the judgment of the Allahabad High Court is, my lord, if your lordship will see, Umesh Chand Vinod Kumar at page 3, and The first issue is whether an association of persons registered or unregistered can maintain a petition under Article 226 of the Constitution for the enforcement of right of its member as distinguished from enforcement of its own right. So association is a juristic person and members are independently juristic persons, my lord. Now, your lordship will kindly see on page 4, paragraph 18. According to these observations, the concept of cause of action and person aggrieved has become obsolete in some jurisdictions like public interest litigation by little Indians in large numbers seeking remedies in the court. In such a case alone, an association of little Indians may be permitted to sue on their behalf. These observations graft an exception to the traditional rule of locus standi. They will not cover the cases of an association suing on behalf of its member where its own members are not affected or where its members do not answer the description of little Indians, my lord. Whether an association...
What little Indians?
Little Indians, my lord, those who are poor, hapless, on marginalized society. So that Gandhi ji has also used that that last man standing...
No, but why the word little Indians?
This is in the context that the little Indians mean those who are poor, they can't...
No, small one.
A small one. Small. That is the... My lord. So the answer, if your lordship will see, the position appears to that association of persons. We have given the list of books also, my lord. Association of persons registered can file a petition to the enforcement of right as in case members of such association are themselves unable to approach the court by reasons of poverty, disability, socially and economic little Indians. That this is one exception, my lord. Now, this was, my lord, if your lordship will see paragraph 12, this was paragraph 9 where I have dealt with the, it is some petitioner has made general and omnibus statement that the association is representing all while needers of so and so alone vital information or mere ipse dixit. This is, they are saying that I am representing, my lord. This, a full bench of Allahabad High Court in Indian Sugar Mill, my lord, at page 6 bottom, held that association cannot file a case on behalf of unless association as an independent entity is affected. Moreover, it was highlighted that order passed in such matters runs the risk of not binding the members of association, and that is also the reason for not entertaining such petition where allegedly directly affected person has not come forward for filing the petition and prosecuting its right. Relevant portions, my lord, at page 7 and 8.
Yes.
The rules and regulations of Indian sugar mills have been placed before us. Learned Counsel is not able to point out any provision of these rules or any act which gives association right to represent the sugar mill of any proceeding before the court or to move an application on their behalf. Without any such express authorization, it cannot be held that association has a right to move the application on behalf of the sugar mills, nor can any order passed in these proceedings bind the mills, my lord. So if lordship will pass the order, whether it will be binding on the members, because if lordship will see in rejoinder they have placed the MOU on my objection, and in that MOU, their article of association, there is no clause which says that the association has been authorized to file case on behalf of members, my lord. Association per se is not retailer before your lordship.
Yes.
Association is independent entity, dealers are independent entity. Dealers have to, their article of association has to say that the association has right to initiate proceeding for protection of interest of the members of the association. The lordship in electricity matter has seen that members are also filing the case, association is also filing the case. So this is the reason why there is a salutary practice where the association says that all members are bound, then only association can do that, my lord. And on page 9, my lord, paragraph 12, I have taken this objection, and in rejoinder there is no reply to all these issues. Even otherwise, it is submitted that petitioner has nowhere indicated that members would be bound by decision of this matter. Honorable Madhya Pradesh High Court in so and so, my lord, and highlighted it has been held that if the same principle is not followed immediately after adverse decision, any other member of the state association may come before the court in an independent petition saying that he has not been heard and he has not been authorized such association on office bearer members to represent him in this litigation. So this is a salutary principle which, my lord, so this is my first preliminary objection. Because association has to say and members have to say that our association is competent and authorized by members, their article of association, that they are pursuing the remedies on behalf of all members. And in article of association, my lord, there is nothing. Now, my lord, the second point, which I take it at page 11, my lord, is there is no article 19(1)(g) is not available to the juristic person, my lord. It is this right is confined to natural citizen, my lord, and this was settled way back in 1963 in State Trading Corporation of India versus CTO, my lord, and in paragraph 15, my lord, at the foot of the page. Yes, my lord. It is paragraph 15. It is enough to say that makers of constitution are fully alive to the distinction between expression and person and any citizen when the constitution laid down the freedom contained under 19(1)(a) to (g) as available all citizen. It is deliberately kept out non-citizen. In that context, non-citizen would also include alien and artificial persons. It is thus clear that right of citizens envisaged in the Article 19 are not wholly appropriate to corporate body. So their case, my lord, why I am citing this judgment, their case is that my livelihood is affected and that livelihood will come under Article 19(1)(g), right to occupation, etc. It is not available to the association, my lord. And one member is there at best, but it would thus appear that makers of the constitution had altogether left out a consideration juristic person when they enacted part 2 of the constitution relating to citizenship and made clear distinction person and citizen in part 3, my lord. This principle, my lord, is again reiterated, my lord, in paragraph 17. I have cited the judgment.
Mohan Raj.
Mohan Raj, my lord. Mohan Raj, it is well settled now that fundamental rights guaranteed under are available only to citizens of this country, whereas other fundamental rights under 14, 20 are available every person who is subject to the law. 6 freedom enumerated in 19 inherent in all citizens by virtue of citizenship without the need for anything further, my lord. And this was also, my lord, subject matter of separate opinion of Justice K.M. Joseph in International Spirit Wine Association versus State of Haryana, my lord. Justice K.M. Joseph in paragraph 46, my lord, said, I would not lose sight of the fact that case 1 dimension regard appellant is an association of companies. Article 19 provides for various fundamental freedom. However, unlike Article 14 and 21, these freedoms are not conferred on non-citizen. In other words, article is not confined to citizen. It is well settled that company through juristic person but not being is not a citizen within the meaning of Article 19. I would take the view that therefore reliance place is not hold good. My lord, these are, I will not multiply with these authorities, my lord. Paragraph 20 also I refer to you. Now coming back to, my lord, this issue of res extra commercium, my lord. So first issue which I have raised, my lord, I have shown the entire scheme of the act under rules, etc. Then I have shown the preliminary objection as that the association is not competent to institute on behalf of the member. Then I have said, my lord, that the Article 19(1)(g) right is available to natural person only, therefore they have no. Now third is that it is a case of res extra commercium, my lord. Yeah. Paragraph 21. It is stated, my lord, paragraph 21, 4th line. It is stated that liquor trade is res extra commercium and there is no inherent right conferred on the petitioner in respect of trade in liquor or demand the fixation of maximum retail profit at per. It is submitted that there is no fundamental right or legal right to carry a liquor. Consequently, the instant repression, my lord, now Harshankar versus excise with taxation in our opinion, the true position governing the dealing in intoxicant as stated in the Constitution bench decision in Balsara and the highlighted portion, there is no fundamental right to trade or business in intoxicant. A state under its regulatory power has the right to prohibit absolutely every form of activity in relation to intoxicant, its manufacture, storage, export, import, sale and possession. In all their manifestation, these rights are vested in the state. Indeed, without such vesting, there can be no effective regulation of various forms of activity in relation. Now, if I say that I will cap your margin to 5%, that is the regulatory power. You cannot question that regulatory power in this form, because in other matters you can come and plead before this court, because in this is the higher power which is given, my lord. And then Khode Distillery, my lord, is a constitution bench judgment. That is the next judgment, my lord. We may now summarize the law on this subject as culled from the aforesaid decision. Right protected under 90 are not absolute but qualified, my lord. We have no quarrel.
Where are you reading from?
I am reading for page 16, 16 bottom of the page 16, my lord. Yes, my lord. And paragraph 60 is the summary. Yes. Kindly come to page 17, sub paragraph highlighted portion. Right to practice any profession or to carry on any occupation, trade or business does not extend to practicing a profession on carrying on occupation, trade or business which is inherently vicious and pernicious and is condemned by all civilized society. It does not entitle citizens to carry on trade or business in activities which are immoral and criminal and in articles of good which are obnoxious and injurious to health, safety and welfare of children. Res extra commercium, there cannot be business in crime. And my lord, next C, potable liquor be beverage as intoxicating and depressant drink which is dangerous, injurious to health and is therefore article which is res extra commercium. A citizen has therefore no fundamental right to do trade or business in liquor, hence trade or business in liquor can be completely. My point is, my lord, that if I can reduce the, so if it can be prohibited absolutely, so whether I have a power to reduce the margin or not, my lord. In the case of, in that context, my lord, what my friend has cited the judgment that I have a power, I have got greater latitude so far as liquor is concerned, so far as potable liquor is concerned. I am not saying that your lordship cannot examine the aspects of the decision making, my lord. That is very much. Now, my lord, next page, next page at page 18. State has therefore the power to completely prohibit the manufacture, sale, possession, distribution and consumption of as a beverage board. It is inherently dangerous. Article 47 can create monopoly in either itself or agency created by it for the manufacture, possession, etc. My lord. Now G. When the state permits trade or business in the potable liquor with or without limitation, citizen has a right to carry on trade or business subject to limitation, if any, and the state cannot make discrimination between citizens who are qualified to carry on trade. So my friend's right is confined to this aspect that I cannot discriminate between the parties, my lord, and I have shown that H, my lord, the state can adopt any mode of selling the licenses for trade or business with a view to maximize its revenue so long as method is not discriminatory. So this is the latitude, my lord, and I rely on this Swiss Riven judgment, my lord. That judgment is paragraph 22, my lord. This is a recent judgment. This to say that experiment, because they say that you have come out with new experiments have been taking place, paragraph 22 at page 21, my lord. In Swiss Riemann Union 2019 4 SEC 17 to 23 in para 22, stay experimentation in things economic is a grave responsibility and denial of right to experiment fraught with serious consequences to the nation. Thus, greater latitude is available in matters of economic policy as the same pertains to complex problem which require trial and error. Honorable Supreme Court took a similar view in the state of MP versus Nandlal Jaiswal, so and so, which was a matter relating to grant of license sale of apex court held that it must be borne in mind nature of trade or business is inherently pernicious, large measures of latitude in determining the policy for regulating manufacturing and trade in liquor, my lord. So these are the direct authorities, my lord, on our point. And one judgment, my lord, at page 25, my lord. Paragraph 25, my lord, at page 22. TB Abraham versus RTA, diminution of income is not, page 22, paragraph 25, my lord.
T. Ibrahim.
Yes, my lord. Diminution of income is not a ground for holding that policy is unreasonable restriction on freedom of trade, because they say there is a diminution of income, my lord. It may be that appellant by reasons of shifting the bus stand has taken deprived the income, but that can be no ground to that any infringement. There is no fundamental right in citizen to carry on business where he chooses. His right must be subject to any reasonable restriction imposed by executive in the interest of public convenience, my lord. And then 26, my lord. Economic policy, the scope of the in small scale industrial manufacture, my lord, and next page 23, which has led to judicial review in economic policy matters is extremely limited. Relevant paragraphs, my lord. Court will not debate academic matters or concern itself with intricacies of trade or commerce. Wisdom and advisability of economic policy are ordinarily not amenable to judicial review. Economic and fiscal regulatory measures are a field where judges should encroach upon a very warily, as judges are not expert in these matters, my lord. And Milord, there are number of judgments, Milord, on this issue. I will not, because all those are I have quoted, Milord. Your Lordship may may take note of these judgments, Milord. Now, the reasons we have also, if your Lordship will see paragraph 32, where the justification is there, integrated excise management system had been introduced for tracking and tracing the movement of all liquor bottles containing so and so different sizes and such a system includes facility of automation of excise functionalities of all liquor bottles with QR code based hologram. There is also facility for real-time monitoring of the movement of bottle. It also provides that all new licenses which are granted after implementing this rule shall install the requisite track and trace hardware at their expenses. System was introduced by notification on 21st January by government. A new rule under 3 was introduced by way of Meghalaya Excise. This said rule, apart from providing morality, cost of implementation as affected from time to time for both software and hardware shall be borne by distiller, bureaus and bottling plant and companies. Milord, this is also making it clear that that cost is not being borne by retailer, Milord. My rule itself 378.9, which I have quoted at page 29, Milord. Now to 33, it is submitted that various other states are also implementing track and trace hardware, and then I have quoted the example of Assam, Himachal, where the similar system is governing, Milord.
Where's Assam? Where is that?
Sorry, Milord, it says paragraph 33.
34.
33. That a copy of the agreement R2 will be there, Milord.
33. You got Assam on Himachal Pradesh.
Himachal Pradesh. Sorry, Milord. No, probably.
Yes.
So the other states are, is there a copy of similar system has been executed by government of Assam and government of Himachal Pradesh. Both states, Milord. Now, Milord, the proper system was introduced, Milord, and then, Milord, the issue is, Milord, if your Lordship will see how much revenue has been generated of late years or last few years, Milord, that data is also given, Milord, is page P18. If your Lordship will kindly come to page 129. Page 129. Last year, Milord, if your Lordship will kindly see page 129, in 23-24, Lordship will see the data, which is 22-23, 365 crore rupees. In 23-24, 434 crore rupees. And 24, budget estimate is 660 crore rupees. Milord, so 20%, if the retailer is having margin of 15%, with the increase of sale, they are earning more revenue. They are earning more revenue. And then kindly see the number of bottles. Your Lordship will see last page of my counter affidavit. Now brand is, Milord, I'm not having much idea because I'm teetotaler, but still page 136, Milord, Imperial Blue.
Even his brand also
is phenomenal increase, Milord. For example, last column, Milord.
Old Monk, yes.
Yes, Old Monk is, Milord. There is 18,500 now, 21,500 cases. Cases, Milord. And if Imperial Blue, your Lordship will see 28,000. No, 2,85,560, 38. It has gone to 4,68,514. So kind of margin they are having. Officer's choice blue is less, Milord.
Yes.
And the judgment, lastly, the judgment of the division bench, Milord.
Yes.
My lord, the judgment of this honorable court, division bench judgment of this honorable court at page 98, my lord. And at relevant page is 115, my lord.
Yes.
Government was the base.
Yes, just come to this.
Yes, 115.
Because Mr. Fukan has made.
He has referred to this judgment, my lord.
With regard to reasonableness.
Reasonableness, my lord. Yes, my lord. But reasonableness, he has to produce the data, revenue, how much earning he was having.
No, he's see what he's drawing up. This division bench judgment on this other aspect.
Yes, my lord.
Has said that still be reasonable, and whether this action of yours
is reasonable,
come within the directions of
reasonable or not. Yes. But first, he has to discharge the onus that it is not reasonable by showing the data and material. The onus will not shift on me. The government was the base judge of nitty-gritties of any economic policy. Though I have discharged. I'm sorry, 115 at third paragraph, my lord, page 115.
They're not numbered paragraphs.
It's not. It's running pages. My lord. No numbering of paragraph. No, in the original judgment, it's not there. Not there. So I can't put it. Only SSC will put it. SSC's renumbered the paragraphs.
In this case,
in all cases, because sometimes the original judgment of Supreme Court will the paragraphs number of original judgment of Supreme Court, they break it as per the issues, etc. Also in editors of SSC do that. 115. The government was the base judge for nitty-gritty of an economic policy, identifying the economic circumstances that require attention and detailed plan and method of tackling it. The formulation of policy to do and so and implementation. This was the prerogative of government. The work was specialized and constitutionalized by the government and consent. Court should not ordinarily interfere unless it is shown that unconstitutional, of law, or most arbitrary, malified, unreasonable, or perverse. Not falling in above categories. Said policy embodied in the impure rule should not be interfered with this court. With this leave the court, with the leave of the court, state government filed an affidavit hearing the matters demonstrated that rule there had been a dramatic increase in the sale. Hence, the introduction of amendment according to London Council augment business of various not affected. Under the it was obliged to keep the demand, and we have now, my lord, the second bonded warehouse. We have got two central bonded warehouse. And finding and observations also. So therefore, to rely to say that, my lord, this judgment helps them, and they kindly see the date of the judgment also, my lord. My policy is prior to this judgment also.
Which policy?
This policy of this is a 424/9/2025.
13/8/25, 12/9/25.
And
this judgments,
and because those are, my lord, where they did 13/8/2025, my lord. The first the challenge is there. So therefore, my lord, to sum up my argument.
12/9/25 regarding that it came subsequently.
So that is the if your lordship will see the
12/9/25 is only for amendment of rule.
Amendment of rules.
412 and C72.
Yes, my lord.
That came after the judgment.
13th August. 13th August.
4/9/25. So 372 amendment of 15% came in 12/9.
Yes, my lord. 12/9 is I think one week, because that process was going 4/9, and then your lordship will see 13th August is before that IEMS system.
Before that.
Before
but what of them is this?
This is 12/9 where we have fixed the margin for bonded warehouse also, central bonded warehouse.
44/12. They don't that CBW
Yes, my
and
lord.
one warehouse.
So
right?
this is also, and this is reasonable, my lord. That is a reasonable in the light.
You want to show judgment?
So that is the only point which I wanted to show, that the greater latitude, etc. the court has recorded also, my lord.
Yes.
And it was also in the context of central bonded warehouse, my lord. Your lordship will So therefore, my submission is that first, petition is not maintainable by association. Second, there is no right under Article 19G. Third, the greater latitude is there in economic matters. Fifth is extra. Fourth
One
is
question that still troubles this court is that regarding association coming. That's the only thing.
Yes, my lord.
Anyway, but then we will.
Association, if your lordship will see their rejoinder, and in rejoinder, because I raised that issue, and in the issue, give me the rejoinder.
Is it registered, Mr. Fulton?
It is registered, but 5 years is also over. 5-year period is also over, my lord.
Register. File the document.
And that your lordship will see page 21 of the rejoinder. So that is, your lordship knows that in those matter in all the judgments where you have to get yourself renewed every 5 years. Otherwise, under the Meghalaya Society Registration Act. But I am not going into that issue because unnecessarily, my lord. But the issue is that, my lord, if your lordship will see their association document at page 21, at 22 is the preamble. 22 is the constitution of East Kasi Wine Dealers Welfare Association.
1 second. Let's go to the rejoinder. That is. Where's the constitution? Yes. East Kasi 2001.
Yes, my lord. And June 2021. Now it is over. The term is also.
No, it's not yet.
Yes, my lord.
And
And
this
then,
will be June 26.
yes, 20. Yes, my lord. And if your lord, no, I am not going on. You kindly see 22, my lord.
Yes.
Aim and object is to promote brotherhood among the wine dealers, to safeguard the interest of members, to take action, so and so. But there is no clause which says that the association has right to file a case on behalf of the members. It can file a case on its own behalf if its own right is affected. If it is a retailer.
No, but the thing is that it's gone across the board with regard to the amendment to 372. It says 15%.
No, but they see,
and they
so,
come the umbrella. See these.
no, so
let's
now,
see,
my
let's
lord,
see the
your lordship has
constitution, they say,
rightly put that question to me, my lord. No, yes, my lord.
Where's experience from assignment and close link among the wine dealers East Kasi?
Yes, my lord. So now the association can espouse the interest of the members. But association, the clause has to be there in the constitution that there is a fine distinction, my lord, that it can file a case on behalf of the members and it will bind the members, and it has the right to file a case on behalf, and members are bound by decision. That kind of undertaking, that full bench judgment, my lord, I have referred to those two judgments where that kind of undertaking, clause was required, and in association there is no such clause. Tomorrow, my lord, that example is that association files and then there is an adverse order. Members will say that I am not bound by the because I have not been heard. I have not authorized the association to file case on my behalf. It is a personal locus standi, which is
that we are looking too far.
No,
Let's stick to the past.
No, but because this is the vital issue, my lord, because this is a legal issue which your lordship should address in my.
Whether you like it or not, once association is formed, the members are bound.
No, that is not the law, my lord. With greatest respect, why members are not members are bound only when the constitution says that I will be bound by the decisions of the and in association agreement. That is what, if your lordship will kindly come back to my counter affidavit. Yeah, if your lordship will kindly come to my counter affidavit, we have raised that the relevant paragraph. If your lordship will kindly see, that is a fine distinction. That's a fine distinction, your lordship will. Please. Is 7 of my counter affidavit.
1 second. Yes.
Yes. Now your lordship will see page 7. A preliminary objection was however raised, middle of the page, on behalf of the government by the London Standing Council that this application is not maintainable as it has not been filed by person whose rights have been directly affected. It is therefore said application should fail on the preliminary point as it is not necessary to go into the other points, my lord. Now next page, rules and regulations of Indian Sugar Mill Associations have been placed before us. Learned Counsel is not able to point out any provision in these rules or in Act which gives the association right to represent the sugar mills in any legal proceeding before the court or to move.
2/3 resolution that they in a meeting that they move.
They moved. That is the requirement.
It's like a company that
And that is in Madhya Pradesh. I have got the authority from Madhya Pradesh High Court. I have got the authority of Delhi High Court, where the direction was issued to that you file the resolution, without failing which I will not entertain. I have got those directions. And why those directions are being passed, there is a rationale behind it, my lord. Because association has not been authorized by the affected party to file it.
That's even a company also that is board resolution will be there.
Yes.
Authorizing certain
Yeah, these are juristic person, my lord. These are the juristic person, and that is why the law is strictly being applied.
This is Indian Sugar Mills, right?
Yes. And your lordship will see this is the line without any express authorization.
Like, of course, Indian Sugar Mills says like the matters brought on to court by strangers without instructions on behalf of the association.
No, even association cannot, if I have not authorized, I am a member of association.
Exactly, that's what he's saying.
And I am a member, and I have not authorized to file a case which affects me. Without any authority, association can, if the association's right, I take the property of association.
So you also convince that it has to be a direct effect on a person.
That is one.
Yes.
And second is that there is an authorization by the members of the association.
Right.
These are the two ways through which
that it has to be direct effect
and authorization. Proper authorization, saying if your lordship
now coming to this case, suppose we say that we hold that 50% is well and good. That means they're not losing anything. That's what they're having their hand only. Suppose we say 15% is bad, 20% given. Then all members will gain. Will they have any grievance either way? Even if they don't have not authorized, they face a situation where
if they say, then the members can independently pursue the remedy. I mean, affected party can again come and say that this judgment is not binding on me. There, if your lordship will see paragraph 9, my lord, page 9 of my counter affidavit, where that is a distinction.
Let's see, interesting point. In this case, because either way, members not really bothered.
No, we have been liberally construing it, my lord. But ultimately, in one or two.
You have not disclosed the members' name, no?
Yeah. No, members' name also not.
Numbers.
That is also not there. There is no.
You have any idea how many members are there in your?
I have been told around 475.
In East Khasi Hill district,
this is only East Khasi.
Retailers, 400 retailers.
Yes.
That kind of shops I have not seen in Shillong or in around area.
I would counter the statement by saying that he's a teetotaler and I'm also a teetotaler. I have also not seen it, but my lord, I have instruction to state that in Polo area there were 47 shops. And yes, now presently. So I will point out that because that is the instruction that I have got. And in East Khasi Hills, that's what has been told to me, around 400 to 450. I do not know the exact number, but yes, that is available.
And they are
450 shops.
Shops, yes, madam.
And they are association. They are association, and they don't have a list of members also. They are association, and they don't have list of members.
There is wall to wall. There is wall to wall liquor shops, wall to wall, where they say they follow Assam. Assam specifically says 100 meters, not followed. If wall to wall liquor shops have been given license. There are 2 shops together. There are 3 shops together.
So then they have grievance.
That's a different.
That's what I was trying to tell you, lordship. Profit.
And they are all their members. And those wall to wall shop retailers are their members.
Absolutely. Absolutely. I have instruction to say that.
These members includes bars also, no?
No, madam.
They are retailers only.
Only retailers, my lord. We only represent
retailers. My lord. So therefore, what my humble submission is, my lord, somebody 5-6 retailers come and they say that I have started the association. They give open, no pleading. No, I raise the objection. I raise the objection in rejoinder. Your lordship will not find details. And whether how many members are there, list of the members are there. All these in writ, when you are filing a writ on behalf of the association, these are the vital. Your lordship has the pleading is very silent on these aspects, because this is a liquor matter, my lord. Here there can be 5-6 vested interests. Why they are against this? system because it is going to stop the spurious liquor. It will have a check on the excise leakage of excise revenue. This is sometimes these are ulterior petitions also. Lordship, kindly think from that aspect also, because see, and they wanted a stay of the process because this is a process through, because hologram ongoing system, everything is going to they did not disclose all these materials, my lord. So therefore I take entire petition with pinch of salt, my lord, that look, when you are saying pinch of salt, that this is a measure which is going to be beneficial for the consumer to a great extent and for the state in revenue stopping, because they have themselves saying at every stage it will be tracked. So yes, sometimes, so 5-6 persons, those who are running the association, other members.
Coming to one point you addressed.
Yes.
Now they have raised one initial point with regard to that implementation of the scheme.
Yes, my lord. Right.
Now he said that
he has some grievance.
Go live at one. That is the agreement.
It will go
of IMES that 1.1.19. Yes. That go live phase, stakeholders, 0 date for go live date.
Yes, my lord.
And like the yes, invoice and billing. So fine. The thing is that now whether now just for a quote.
Yes.
Whether this is all gone live now.
No, my lord. That I will take instruct. But what is the process which I have understood from the officers is
no,
that
what has gone live and is it correct that now they have not been provided with those scanners? They're not provided with the QR readers. Now whether
it will be in phased manner.
Whether now is not exacting a revenue which is not justified in the sense that you have devised a scheme where you will charge this IMES, fine, well and good, that's within your powers, absolutely.
Yes,
but now whether in the implementation of this, how you've done it, and whether what they're contending is correct, that without the scheme going live as per the stated agreement.
If I see in the writ petition, my lord, in the writ petition there is
that even there's a roving inquiry which the court can go into.
No, I am not saying that. Court can definitely look into all these aspects.
Deriving,
working, your lordship can definitely examine the working. I have no issue. Your lordship, I am not saying that.
You have not answered that point.
No, I am answering. I am coming.
Now the thing is that what they've argued, okay, fine, they're trying to link this implementation with the reduction in the profit.
I'm grateful.
Okay, you're sticking to reduction in profit with regard to the power of the state government and excise rules to put forward these.
No, I will be more than happy.
It's well within, but now another factor which is worrying is that when somebody you see it's a very fantastic system which will face purist liquor and all, but whether it's efficacious at all, if it's not go live and they're charging.
No, so
imagine if you see the total volume for your table has gone so high. So imagine amount of revenue generated without any.
No, see, your lordship, the issue is that they are twofold. What I follow.
How are you tracking it?
No, I'm just answering. I'm answering the question, my lord. That 2 rupees 40 paisa is IEMS charge. This money goes to whom? To go to me. Ultimately, all prices will go to the state government.
No, how you said this? Now you see, I'm taking the pressure of pinch of salt. Now how you change?
No, I'm
you can't read it.
No, I'm answering, my lord. Kindly give me a moment. I will answer the queries.
Or you have to conclude at 4 o'clock.
2 minutes only. 5 minutes maximum. 2 minutes. Now, your lordship is saying that we have implemented the system.
You have not implemented the system.
No, we have to go because we have to create the hardware, software, all these tracking, etc.
So why you implemented? Why are you charging this rate now?
No, now the question is, this is part of the cost price. Your lordship will kindly appreciate that this will go into 241 one hologram, etc. Whenever the hologram will be fixed, whenever this will be fixed, that will be charged. Inbuilt cost will be there in the cost card, my lord. Your lordship. And that so once the 240 paisa is being charged from whom? From the consumer, not from the retailer. He's not getting to.
What the court seeing is just another gimmick which is being done.
No, my lord, that your lordship with greatest respect.
Because that is some consumer. Okay, both of you might be teetotalers, but other thing about the poor consumers. See, liquor is paying for the entire. It is the third largest revenue earner, I think, in the state.
Yes,
right. Huge. So, it pays for a lot of basic, amenities and all.
Yes,
so at least the consumers get a fair deal also.
No, I understand, my lord. The concern which I will express to the government also.
How has it gone live? This is what the question is still hanging.
No, I will ask the officers. I will file a note that how? No, because see, because problem, my lord, is that he says that it has not gone live. Because what is the material? Suddenly.
That's why you were expecting some material to show that yes,
he
has gone live.
If I have to, because my lord, if he goes, the problem which I face all the time, my lord, they will come and they will say orally, this is not working. Do I have time to take instruction whether
it is not working?
This is it has not gone live.
Department.
No department. I will ask the officer. You tell me, explain to me. I will place it before your lordship, because they are saying that it has gone without any material, affidavit, etc. What is the material and how it is connected to their?
But then the onus on you to say that now we are charging because the fact remains that the charge being levied. Right.
I am not charging him, my lord. I am not charging him.
Irrespective, my charge A, B, C, D down the line. But show us how it's gone live.
That I will place it. That is no problem. That I will place it. I will find out how many scanners are fitted.
We have to know the entire spectrum. The things that,
Lord, okay, because fine. See, they have challenged my policy decision.
Legal arguments, fine. We understand where his rights are or what the government powers are. But the thing is that we have to understand that in transparency also demands that that the.
Is it transparent, my lord? If they would have challenged before your lordship. The challenge would have been to that this is not working properly and it is defective.
So they came by miscase later on.
And now the problem is that in miscase also I don't see what is there, my lord. In miscase is not there. My problem is this only. If your lordship will expand the scope, I will place the material also on the working. That is not a problem, my lord. But it is working fine.
Yes.
So the issue is, and then, my lord,
Mr. Arpeja, I think you have to make replies.
Not too long, my lord. I'll just take 10 minutes. That's all.
That's the point which I have made. And recent judgment, my lord, the recent judgment which came.
We need your notes on submission.
We'll
take 10 minutes to clarify two things, and then I'll leave it to your lordships, because he has raised a very important issue about the association not being registered and not having the powers to come up before your lordships to file a writ petition. In fact, the order that my learned friend is relying in the counter affidavit, which the High Court has given a direction at page 98, which the High Court has passed an order, is also International Spirits and Wine Association of India. So the petition that was moved was also by an association. No questions were raised as to whether the people have given them an authority to file it. Plus, I have judgments to show of the Supreme Court, and I have distinguished them in my rejoinder, saying what is the power that is available. I'll just take 2 minutes to show my rejoinder, where he has said that the association is not registered and doesn't have a power to buy. That may not be correct. Number 2, my lord, in regards to 36 and 21, my para 19 and 20 are very clear. I am not on the power of rule-making power. Absolutely not. They have absolute power to do it, but that has to be done in an absolutely equilibrium method without any policies of arbitrariness or discrimination. Number 3, rest extra commercium. The moment I'm a licensee, my lord, under this provision, because this is where I run the. I have rights which is equally under Article 14 and 19, because the trade would have been rest extra commercium if I have not been under that protection. The protection is given by them. Therefore, I still have that right. Number 4. And they're saying that the scheme has been implemented in Assam. Yes, scheme was implemented in Assam, but you can take it from my lordship, it's a statement made with the bar that there is no scanning that has happened in Assam also. No scanning has happened in Meghalaya. On the last occasion, my learned friend had said, on 1st of October, it has gone live. If it has gone live on 1st of October, it needs to be scanned. Manufacturer, central bond, state, and the retailer. They must have scanned all the information will be available.
Also because he has not.
Yeah, my lord, the answer is
I don't have that information.
The issue is, my lord,
he'll have that information.
The issue is, my lord, that what my friend is that it has gone on live on 1st October.
But that's not my statement. It was his statement on the last occasion.
So then it may be in phased manner, or it may have gone live also. That information I may not have. My lord, only thing is that my friend has relied on that Jharkhand judgment that is under consideration before the Honorable Supreme Court.
Yes.
When he was relying on the judgment, my request was that he should have pointed out this also.
Absolutely.
Recently in Delhi High Court has.
No, but we'll fix one more day.
And your lordship, there is a recent judgment yesterday delivered in these matters by the Supreme Court, saying that the scope of judicial review is limited. My lord, these
alcohol matters.
In revenue matters, my lord, in property.
In regards to the Jharkhand matter, it is pending before the Supreme Court. The reason I did not say, my lord, is there's no stay on that. They have only issued a notice. The proceedings have been completed. That Supreme Court has only pended. And only in regards to a deposit of certain bank guarantee, they have only interfered by saying that deposit should be made. There is no stay on the judgment. So that I have also have.
My lord, just now I have got the note also.
So that is available.
Regarding implementation also, it was in the file because that was the issue.
Of IMES.
Yes, my lord, that is there because I did it was not in my mind also regarding implementation aspect. Lord Civil, the department, whatever department has given.
No, this is just a plan.
Yes, my lord, if you Lord will say, yes, my lord, that has done survey, so and so, location, supplies, hard work, so various stages, my lord. If Lord will say, I like bottling unit 6, yes, brewery, yes, commission office, yes, my lord, software development, yes, whatever is there.
See, IMES application is in live from 1st of November and following operations are functional from the application. Various stakeholders are using IMES application, various exercise activity mentioned below. Let's see activity.
Yes,
Central license registration, renewal, brand registration, bottling, production, CBW, retail, online indenting, online payment, day closure, data analysis, online indenting to depose. Okay. So it's that means it's online, it's gone live.
Yes.
Give a copy to Mr.
He can bring it in an affidavit also if
Why
required.
there is no, because this is not the issue. I take serious objection to me, my lord, because they cannot. I can give it. That is no problem. But they have no right to, if they are raising objection, my lord, and then my lord, on association issue, I will give it. That is not a. But the pleadings are because this is all they know. They should have brought all these matters.
How will I bring it, my lord? It is with them. They are supposed to scan it. It is their software, their hardware, my lord.
And
if they scanned it, that information will be available with them from 1st of October, whatever they have sold. Where is the money going from there? They will have all those records available, my lord. I don't
money will go to the proper process only.
Because there's no money being collected. There's no scanning happening, no, my lord. Either from the manufacturer till retailer. That information they will have,
let him put it in an affidavit. I'll file 340 application. I'll put it in an affidavit.
41 crores, 27 lakhs, 56, batch 24 lakhs. Okay, yes, no, but then the process.
Yes.
May I just have a copy of this, my lord?
And my lord, I kindly see the. I will give the copy, my lord. That is not the issue. But kindly see the Delhi High Court judgment on the resolution one, in the board resolution one, the two recent judgment, the judgment.
I think you give your note submission.
Yes, my lord, just see this judgment.
Just for closing arguments.
Yes, my lord, kindly see the Delhi High Court judgment on that aspect, my lord, on board resolution.
We shall see everything.
Only one line.
No one can shut you down.
No, I understand, my lord. It says, my lord, that to bind the members of decision of litigation brought before the court.
You have to pay one more visit.
My lord.
Yes, we'll fix it again on now the 9th.
Yes, my lord. It's been going on. We've been trying for a hearing, but
no. I mean, this hearing is more or less concluded. Would you give your note submissions? We'll fix it on.
I'll give the submissions.
17th, last date, my lord. 17th.
17th, the bench is not here.
16th. Yes. 16th. We'll put the.
We'll give you half an hour. 15 minutes.
We'll file.
I'll also file the written arguments, my lord.
Yes, just
written arguments. We'll file written arguments.
Yes. She can note it down also. List on 16th for further hearing. For final for further hearing. Stop parties also to submit their notes and submissions. Notes and submissions on that.
We'll do that.
Yes. We'll reserve it on 16th. Sir.
Yes, my lord. Yes. Because nowadays, so tracking judicial data grade is also big problem matter, and they are big issue.
Yes, now we get directives also if some matter you
sometimes it slips out of my mind also. Sometimes it happens when the file is pending and it happens, and then
there was a testimony matter in my board also.
There was
been heard. It's nothing. It's only a form, but the file went underneath, and and then we forgot about it.
It's extremely grateful.
Grateful.